May I be the Lordship? Yes. So item number 1, my lord. Maybe some other day, my lord. I'm sorry, my lord, maybe excuse my lord. Just now I have received a phone call from the nursing home. My elder brother has been hospitalized due to some cardiac ailment or minor stroke. I don't know. I'm not sure, my lord. Maybe it's after 2 weeks, my lord.
You're for the petitioner,
Yeah, I'm for the petitioner, lord.
Mr. Ahmed.
Yes,
Yeah.
lordship.
Mr. Mohammed M.U. Ahmed, learned counsel for the petitioners, submits that he has some personal difficulties
Right.
to conduct the case today and prays for adjournment for 2 weeks.
Lordship.
Anyone for the other side? Any objection? Okay,
Oblige.
since no objection is raised from the other side, matter stands adjourned for 2 weeks.
Oblige.
My lord, I pray for listing of a writ petition, new writ petition tomorrow, my lord. There is an urgency, my lord.
What urgency is that?
My lord, I have been serving as an principal in SARS
Okay,
for last 2 years, but suddenly I have been removed as an assistant teacher to another school. I have been demoted, my lord, without following due process, my lord.
where's the date of the order?
My lord, 7/10/2020.
7/10.
I was directed to join in the new place of prison on 10. I was on leave. I have submitted leave petition. Thereafter, honorable court was closed, my lord. Holiday, my lord. Thereafter, I filed the writ petition yesterday. Urgency is there, my lord, tomorrow.
All right.
May I please, your lordship. With the consent of other side, my lord, I beg to mention item number 16, 17, 18 and 19, my lord. I have taken consent from the other side, my lord. Maybe taken up
You're for the petitioner.
petitioner, my lord. Maybe taken up, my lord, after a week, my lord.
Okay, you're Mr. Barua?
R. Sharma.
R. Sarma, okay. You've circulated some adjournment slip also.
Yes, yes.
Mr. R. Sarma, learned counsel for the petitioners, submits that he has some personal difficulties to conduct the case today and face adjournment for 1 week. Stop, he submits that he has taken the consent of the other side. Stop next for us, since the okay, in view of above, matter stands adjourned for a week.
Oblige.
May I please, your lordship? Lordship, I beg to move an unlisted matter today itself, unlisted matter. The matter pertains to college election. The matter is that yesterday the final list was declared in which the guidelines issued by the Honorable Apex Court in Lindo Commission was not followed, and students against whom disciplinary proceedings has been going on has been given the nomination. Moreover, the petitioners were rejected on the ground that their attendance is below 75%, but their attendance is above that. So yesterday the elections final list was declared, and moreover they have not also disposed multiple representations submitted by the petitioners. Also the final list was declared yesterday and elections are tomorrow, lordship. So I just pray if today, lordship, in the second half, if it can be taken up. Because or else the matter will become infructuous. Tomorrow is the elections, and yesterday was the final list was issued, and the authorities have also changed the date during from the date of issuance of election till today. They have changed the date multiple times. First, the list was supposed to be declared on 11th, then they have changed it to 13th. So accordingly, the final list was again postponed to yesterday. It was, so that is the reason yesterday the list was declared. We have filed the petition today itself morning. So tomorrow is the election. That the matter will become infructuous. So I pray if my lord can.
If the writ petition, subject to the writ petition being ready, you're filing only now.
We have filed it.
You have filed it.
We have filed it.
You have a filing number?
Yes, we have filed it.
What is the number?
E-filing number is AGA 2025 00087C 2025
And who's for the other side?
Government, the
Government?
higher education is there.
You serve them copies?
Yes, we will. serve.
Okay, we'll
Yes.
see at 2 o'clock.
Yes. Much obliged.
May it please your lordship.
Yes.
Which of lordship indulgence, I beg to mention for listing a motion matter tomorrow, lordship. Urgency is there, lordship.
What is the evidence?
He was suspended 1.5 years back. The order was never reviewed or revoked, lordship.
That can come next week, not tomorrow,
Maybe on 22nd, lordship.
on Wednesday. Wednesday is motion day. isn't
Motion
it?
day, lordship.
Come on Wednesday.
Obliged.
May it please, lordship, I beg to mention item number 8, lordship, the contempt matter. The matter be kindly be adjourned for the day, lordship.
You are for which party?
I am for the contempt, lordship.
LH Contemna.
Lordship.
What is your name?
US Boda. I am
Sure.
appearing on behalf of Mr. S. Borthakur.
Oh, you're for the petitioner.
Petitioner.
Then why are you saying you're for the contemner?
Sorry, Lordship, petitioner.
Why you want adjournment?
Lordship, learned counsel, he has certain personal difficulties, Lordship. He could,
Adjournment for how many days?
for the matter may kindly be listed on 23rd, Lordship.
No, we'll fix after 1 week.
Lordship, 23rd.
As per the, no. Date will be given by the registry, you see. Mr. S. Borthakur, learned counsel for the petitioner, is said to have some personal difficulty to appear before the court today. On a prayer made on his behalf, matter stands adjourned for a week. Will be listed on a date to be fixed by the registry.
Lordship, the petitioner will be retired after 20 days, Lordship. That's why the matter will be in flux to us if it is not fixed on 23rd, Lordship.
Then do it today.
Lordship. Lordship, the matter may.
We don't require your services, you see. This is a contempt petition.
Lordship.
It is between the court and the alleged contemner. But still you are insisting on granting time.
Lordship, at 2, Lordship.
Why at 2? How many matters are listed today? There are 19 matters and half the matters being adjourned.
Lordship,
So court will have to rise by 11 o'clock.
we'll do it today only, Lordship.
Okay, no adjournment. Cancel.
Lordship.
You wait for your turn.
Lordship.
May it please your lordship, I beg to mention one repetition for admission by next week, your lordship. Notice of motion was issued on 25/6, your lordship.
Madam, you approach the registry for admission listing. All right.
After vacation, your lordship.
You approach. They will accordingly consider and post it. Yes,
May I please, your lordship? I beg to mention item number 12, your lordship.
yes.
Your lordship, on the last occasion, honorable court had directed me to file a list of dates, your lordship. And I have exhausted all the means to contact the petitioners, your lordship. Even though I believe that they have got my message, they are not coming up and not giving me details. So I want to serve them a notice, your lordship. Kindly give me some time, your lordship.
How much time? 2 weeks.
Yes, your lordship, 2 weeks.
Okay, as paid for by Ms. P. Das. Your P. Das.
Yes, your lordship.
Matter stands adjourned for 2 weeks to enable her to obtain instructions from our clients.
Deeply obliged, your lordship.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 2 and 3, Lordship. I'm praying for adjournment of this matter.
You are for the,
Petitioner, Lordship.
ah,
Praying for adjournment, Lordship. We have
praying for
submitted the-
adjournment.
Lordship.
Why do you want adjournment?
Lordship, my senior is out of station, Lordship.
You have circulated the adjournment slip?
Yes, Lordship.
See, one thing which is, I don't understand is in the adjournment slip. We cannot make out who is seeking the adjournment, either the respondent or the petitioner. Both parties have signed.
I'm seeking for the petitioner, Lordship.
That's right, but the slip does not indicate that. Adjournment is sought by petitioner like that. One side respondent signs, one side petitioner signs. So we don't know whether it's the respondent seeking time or the petitioner seeking time. Something, I think the adjournment request has to be, is this a standard format?
Lordship.
At least there should be one column saying that adjournment sought by advocate, which advocate? For the petitioner or for the respondent, like that,
Yes.
so that we know. I was under the impression that the respondents are seeking time. Okay, okay, no objection. Your good name?
K. Kashyap.
And how much time do you want?
1 week, Lordship.
Mr. K. Kashyap,
Appearing on behalf of IH Vaikya, Lordship.
appearing on behalf of Mr. I.H. Saikia, counsel for the petitioners, submits that Mr. Saikia has some personal difficulties to conduct the case today, and therefore matter may be adjourned for a week. Stop. Mr. F. Ukan, learned standing counsel, elementary, has no objection to the prayer in view of above. Matter stands adjourned for a week. All right.
Deeply obliged. May I please, your lordship? Prayer for listing WBCA number 2980 25. Matter regarding for pension. My lord, kindly see.
Please go to the registry and inform them, and they will look into it. Okay.
Published.
My lord, in this case, my lord, this is order of 9/5/2020.
For the matter for time being, and the other name may be late on another code, my lord.
Okay, yes.
My lord, this is matter of order or judgment of this honorable court dated 9/5/2022. Petitioner is retiring very soon
What is the direction?
to provincialize his service as
Okay.
teacher.
Show me the relevant portion.
11%, page 20, my lord. Page 20, paragraph 15. Even even the provincialization of private respondent number 6 is also set aside. But his provincialization was cancelled immediately after this order. But my provincialization is not done, despite of personal appearance, so many orders, my lord.
What is the name of the petitioner?
Director, my lord, Suranjana Senapati.
Petitioner, name of petitioner. Name of the petitioner is director?
Oh, no, sorry, my lord. Abu Khair Sheikh,
So Abu filed writ petition,
my lord.
correct? And what was the prayer there? What was his grievance?
My lord,
Recommendation of district
no,
scrutiny
my lord,
committee.
contempt petition. This is contempt application.
Oh, I know, Mr. Counsel. In order to understand what is the order not complied with, I'm asking you the facts.
Facts, my lord, my name was dropped by the district scrutiny committee. Thereafter, and in place of me, the name of respondent number 6 has been recommended.
Okay,
So I have challenged his provincialization.
you have challenged.
My lord.
Now, what did the court do now?
Court, my
Decision.
decision. And this honorable court has set aside the provincialization of respondent number 6 and directed to consider my provincialization.
Please read paragraph 15 of page 20.
My lord, therefore, taking into consideration that the petitioner is the senior language teacher and the action of not recommending the petitioner by the district scrutiny committee, which was approved by the state level scrutiny committee on the ground that the petitioner was headmaster and as such not eligible for provincialization due to non-availability of required enrollment is on the face of illegal and arbitrary. Consequently, this court therefore interferes with the order of provincialization dated 5/2021 made in favor of the respondent number 6, thereby setting aside the same and further directs the respondent authorities to consider the case of petitioner for provincialization as a language teacher in so and so school. The exercise may be completed at the earliest and not later than 45 days from the date of certified copy of this order is served upon the respondent number 2.
Okay, when did you serve the copy?
I have served 3/6/2022, page 21.
Where is the date? Okay, handwritten 3/6/22.
20.
After that, what happened?
My lord,
They have not complied with it.
till date not complied with.
They have filed show cause reply, affidavit,
No affidavit is
affidavit not filed.
not filed. My lord.
When did you file the contempt?
I have filed contempt on 1/8/2022.
Then you have again implemented new party, isn't it?
That is my
New
lord,
incumbent. Over.
not new incumbent. commission, secretary, my lord, but direction is issued to the director, my lord, Suranjana Senapati. My lord,
Mm.
page 20. May
No.
they-
You have, after filing of the contempt, you have impleaded again the secretary, is it?
again secretary.
When was it impleaded? When was he impleaded?
I think, my lord, the last occasion, my lord,
Why was he impleaded?
because, my lord, they are saying they have sent the sent some letter to the secretary.
How? Any document given to the court? Any affidavit?
Not affidavit, I
So
think.
on what basis they are saying that?
Some
matter settled.
letter has been produced, my lord.
Who's appearing?
And Jay Kapanier will appear, my lord, here, man. He is on late.
All right, let him come. We'll see.
My lord. After some time.
After some time. Time.
Time.
It was item 6, isn't it?
Seven and nine, Lordship, are the identical matter, Lordship. The same arising of the same judgment, Lordship. And you kindly please the order dated 18/8/2000.
Why is it listed today?
Lordship, they are directed to file the compliance affidavit, Lordship. But they have not filed.
My lord, process of examination is, my lord, going on here, my lord. Records and documents all are examining here. And my lord, and regarding the amendment of provision, relevant provision of provincial election of 2017 Act also has taken the step and it is in process and is in final stage, my lord. So some time may be required, my lord, here.
Orally, we're not granting you time, okay? You should file your show cause reply,
Yes, ma'am.
explaining the steps you have taken and why you could not comply till date. Why you require some time. You write, give that in writing. Verbally, I'm not accepting.
Some time may be granted to file our affidavit also possible.
What is the order? Let us see the order.
Page,
Third.
relevant page, Lordship,
What, this is a
40.
common order?
or Lordship.
The common order.
Common judgment.
Annexure 2 is the judgment, isn't it?
Judgment, Lordship, page 40, Lordship.
Just a
Re-
minute, just a minute. Annexure 2 is the beginning of the judgment.
Lordship.
How many writ petitions are disposed of?
Total,
And the present contempt is the petitioner in which writ petition?
Lordship,
Abdul
page
Basi.
17, Lordship.
Abdul Basi.
17.
Hmm. Page 17.
Lordship, 17. 174759.
2012.
Abdul Barik, is it?
Abdul Barik, Lordship.
Barik.
Lordship.
How many petitioners are there?
Your Lordship. 7 petitioner, Lordship. In this,
Contempt is also filed by all of them.
Lordship, on the, all of them, on the, I appeared on the 8 writ petition. 8 numbers of writ petition. They have all filed, Lordship. In separate contempt.
No, you're concerned with Abdul Barik and others, isn't
Lordship,
it?
Lordship.
WPC 4759.
4759.
There are
There are
7
7 writ
petitioners and the present contempt petition is filed by
filed by the,
how many? All of them?
not, only 5.
5.
5.
But they all are petitioners in WPC 4759.
Lordship.
Okay. What was the grievance?
Lordship, give us their school was not provincialized due to the non-inclusion of the name in the dice code, Lordship. And as per the 2017 Act, Lordship, the dice code is not relevant for the provincialization of the higher secondary school lordship. And please,
Just a minute. Dice code. Then what is the finding of the code?
finding on the page 40 lordship, paragraph 19.
Please read paragraph 18 onwards.
Lordship, this code on the basis of the above analysis of the provision of the Act 2017 is for the opinion that the instant of the respondent authorities of the names of the petitioner who have not been rendering service in Fanshawe High School and Fanshawe Higher Secondary School, where the higher secondary school be captured in the dice code of the 2009-10 is contrary to the Act 2017, as it is not the mandate of the Act of 2017 to fulfill such requirement in respect of such teachers and or tutor working in Fanshawe High School and Fanshawe Higher Secondary School to have their name captured in dice code up to 2009-10. Such instance is arbitrary and contrary to the provision of this Act of 2017 and accordingly interfered with it.
Okay, now this was disposed of on 12/4/23.
23, Lordship.
And you have supplied copy on which date?
Lordship, on 28/4/2023, Lordship.
Where is that? Any acknowledgement?
Acknowledgement, Lordship, I served the copy directly, Lordship.
What is the proof?
There is a endorsement, Lordship,
Where?
in the order copy, Lordship.
Page number
Page number 11, Lordship.
11.
11, Lordship. Lordship.
Endorsement by whom?
Lordship, by the office of the director, Lordship.
Where's the seal?
But they have endorsed, Lordship.
Mr. Counsel, this is not the way to serve copy.
Lordship. But the
It's a serious matter. You're giving a copy and you're filing contempt also.
Lordship.
You have to be very 100% sure that they receive a copy. You should have insisted on a seal
Lordship.
or at least a forwarding letter where they receive it.
In page 11A, Lordship, there is a court cell, there is a endorsement. See.
We don't know. You see, all this handwritten thing, we don't know. What is this?
Lordship.
You should have ensured.
Lordship,
How many respondents are there in this case?
respondent 2, Lordship. Director and secretary, Lordship.
You are for which party? Mr. Counsel Sharma,
I'm for the respondent number 1.
1 and 2. Both. You don't dispute that you have not received a copy, isn't it?
Yes.
What do you say? You have what does your instruction say?
As per my instruction, my lord, the records, physical documents and records are examining. And moreover, my lord, the process of amendment of relevant provision of a Provincialization Act 2017 is also going on. Some step has also been taken by the department.
So how is it relevant to this case?
My lord, regarding the UDICE.
No.
UDICE matter, yes.
Court comes with a finding that entering the dice code is not necessary for venture schools.
Yes.
Now, instead of complying, you are trying to amend the act.
No, my lord, the process of, besides the amendment of the process of amendment of the act, the process of, my lord, physical documents verification and records are examining by the department.
When will you complete the verification?
3 weeks may be granted.
If nothing happens in 3 weeks, then you'll come in person, Director. This is a judgment of 2023. 6 months time is given. It's more than 2 years now. Yeah, all you can say is that we are examining. Mr. Sharma, you impress upon your clients. Impress upon your clients that if they don't take things seriously, they will have to face the consequence. Court has passed some order. Only two ways are there. What are those?
One has to comply, otherwise go to inquiry.
Go to a larger forum. So if you're not doing either of those, then you will have to face the consequence. Please write down non-compliance of the judgment and order dated 12/4/2023 passed by this court by way of a common order, with the lead case being WPC number 1353 of 2022 is being alleged. Stop. The instant writ petitioners are some of the petitioners in WPC number 4759 of 2022 covered by the common order. Stop. Learned counsel for the petitioner submits that time granted by the court was 6 months to comply with the direction. But till date, respondents have not taken any steps, and hence the contempt petition. Next para, Mr. U. Sharma, learned counsel appearing for both the respondents, submits that verification of documents, etc., are being carried out in furtherance of the direction given by this court, and prays for 3 weeks' time to come with the up-to-date status. To stop, it is seen that more than 2 years has lapsed since the passing of the judgment and order. And therefore, the respondents ought to have complied with the direction by now. Stop. However, since time is being sought, court grants 3 weeks' time to the respondents to come up with the compliance order, compliance report. Failing which, consequential orders will be passed. Next para, list this matter again on so and so.
Kindly maybe 2 weeks, Lordship.
1811. I've said so much, okay? And leave it to the court to decide. It is your duty to bring to the notice that this order is not complied with. The remaining part will take care. All right? Why do you say 2 weeks? Any urgency?
Lordship,
Then?
they are 2012.
No, don't aggravate the things. See, I have already said so much in the order. Mr. U. Sharma will make sure that you convey the message to the respondents. All right? They have to take up the matter in right earnest.
Item 9 or same
9 also same.
same direction.
How can it be same?
Lordship, it is the same judgment.
No, judgment is same,
Same.
but it cannot be same. See, I'll tell you. In item 9, who are the petitioners? What is the writ petition number?
On page 15, Lordship. 1366.
Okay, then you write
66
of
2022.
okay 1366 of 2022. This one you will insert instead of this 4759 I gave earlier. This much you replace. The remaining will be same.
Problem.
Wait, Mr. Lordship. The order is at page number 11, Lordship, the contempt petition. Very relevant portion, Lordship.
Just a minute. Page 11.
Page 11. last paragraph.
No, before that, let us see. It starts from page 9, isn't it?
Lordship.
What was the issue?
Lordship, the petitioner, by way of instituting the present proceeding, has presented a challenge and order date 13 issued by the Director Challenge, by which the respondent number 4 herein was allowed to hold the charge of headmistress of Kalugaon High School.
Okay, so that was the bone of contention,
Lordship, and
being the in-charge headmistress.
in-charge headmistress.
Respondent number 4 was given.
Yes.
So you
Lordship.
challenge.
Yes, Lordship.
Because you are senior.
Lordship.
Then what is the direction?
Direction of the Director, Secondary Education Department now shall allow the petitioner hearing to function as the headmistress of the said school till the post is so filled up on regular basis in terms of provisions of Assam Secondary Education Services Rules 2018. This is Rule 14. So as per Rule 14, we were allowed to hold the post of headmistress in charge, Lordship. And this order was never challenged by the department. So the order was passed on 21/6/2024, but the order was never challenged by the department till date, Lordship.
Okay.
Now they have filed one additional affidavit in opposition, wherein they have contended at page number 18, Lordship, paragraph number 9.
Yes.
And they have they say that the Rule 12 of Assam Education Services Provincial School herein referred the Rules 2018 provides the provision relating to recruitment to the post of principal. And they say that we have attained the age of 55 or 57 years. That's why we cannot become the headmistress. But Lordship, we were given the post of headmistress as per Rule 14 of Secondary Education Services Rules. And
What does it say?
recruitment to the post of headmaster, superintendent and procedure. The post of headmaster of high school and superintendent of high madrasa shall be filled up by promotion from candidates amongst the graduate teachers as per district-wise seniority list on the recommendation of the district selection committee. This, Lordship. The selection of headmaster and superintendent shall be based upon seniority and satisfactory annual confidential report for last 3 consecutive years as per procedure under rule. There is no mention about any sort of ages, Lordship, in this rule. Age is required to become principal as per Rule 12, but there is no age requirement for the post of headmaster as per Rule 14, Lordship.
Okay, then who's for the respondent? How many respondents have you read?
Respondent, Lordship.
Anyone appeared for the respondent?
My lord, MJ Khatuniar will appear, my lord, here. My lord, he is on late, my lord. For the sole respondent.
After 20 days, Lordship, he will be retired. Actually, that's why we were in a hurry, Lordship.
Anyway, I'm not adjourning it. Let him come, Mr. Khatuniar. We'll ask him also. What
Lordship.
is happening?
Lordship.
Time being?
Time being.
Passed over for time being.
Code number
You inform him, let him come.
Lordship.
There are 2 matters pending for time being. Because of Mr. Khatuniar.
Obliged.
Yes.
May I please, Your Lordship? The petitioner hearing is the headmaster, my lord. And he joined as headmaster. The school was established in the year 1985. And he's the founder headmaster, the madrasa, my lord. He joined the service on 1/6/1986. I had prepared him a lot short notes, my lord.
You must have made some synopsis also. You read the synopsis. Let us see what have you written.
My lord, here, my lord, we have filed affidavit. We have filed affidavit in the department.
Yes, so
That is status of the DP's.
what are you saying? Please say clearly.
Yes, my lord, that DP is going on, my lord. Whether it's status of that DP is has to be inspection.
DB is going on means what?
Departmental proceeding.
Or DP
They say in their affidavit, my lord, that departmental proceeding is on. But
against the petitioner.
petition. But as on date, my lord, I have not been served with any charge sheet. Unless the charge sheet is
Sir, they cannot say, my lord, the departmental proceeding is on. In fact, my lord, contemplating departmental proceeding, they placed me under suspension. Suspension was revoked without holding the departmental proceeding. And what they did, my lord, while revoking the suspension, they curtailed my position of DDO of the school. The writer is suspension is revoked, but however, he will not be allowed to handle financial matters. That is the issue. The issue is, my lord, that a scheme came for minority students. That student in the previous year must secure 50% of the mark, and their parents are below 1 lakh per annum income. That is the criteria.
Okay, what is the prayer in your rate petition?
My
What are-
prayer is to remove that portion of my lord, that I may be given the power of DDU.
What are you now?
I am headmaster.
Headmaster, in charge,
No. full-
regular headmaster.
headmaster, my
But
lord.
DDO power has been
Power
taken
has
away
been-
from you.
That is,
So you want that back?
yes.
Okay.
Now that scheme came, my lord.
All
Scheme
right, see, we'll do one thing. Mr. Pegu, is that your instruction that the EP is going on?
Yes, master.
Hmm? But show me a document how DP is going on.
In our affidavit, it is written.
My instruction is, my lord, as on that, no such thing.
Hmm. You as per your affidavit, where? Show me.
Yes, my lord,
65,
69.
69. Paragraph.
Paragraph 12, my lord.
Read.
Moreover, petitioner has been reinstated in his original place of posting for utilization of his service except the work related to financial matter till completion of CID investigation. My lord, so that apart from the departmental proceeding against the petitioner is already initiated, my lord.
When did you file this affidavit?
But
9 May 2024.
yes,
So you get instructions by next week. If there is no DP, or whether the DP has been drawn by giving charge memo, and whether the CID investigation has culminated into filing of charge sheet.
Charge sheet also, my lord, there is no, not mine.
my lord, that how many
No, you also the department, isn't it? You should know what is happening to your officer. Investigation will be done by the Home Department or the police, whoever, no doubt. But since you are the department, you are the employer, you should be knowing what is what. Depending on with the matter. Because counsel for the petitioner says that I have no knowledge about any DP, no charge memo. So you are relying upon an affidavit filed in May 2024.
Yes.
So a lot of things might have happened. If nothing has happened, then we go ahead. Okay,
Lordship, I'm on.
You are
behalf of
for?
Respondent number 3, your lordship.
who's that?
Director, Assam Minorities Development Board. And we have already, we have been made a party here and we have already filed an affidavit on 29/4/2025 in this regard.
You sometimes it's coming, sometimes it's going. I don't know what is happening.
Let both the charge sheet be placed before your lordship. Charge sheet in the
you-
criminal case,
You are the headmaster of which school?
Pahartori ME Madrasa.
Where do we get that?
Uh,
Okay, yes, please write down. The petitioner is the headmaster of Pahar Tari
Habibi,
Habibia ME Madrasa under the Samaria block, Kamrup. and he was placed under suspension on account of certain allegation. So although he has been reinstated, but the DDO power has not been given to him. Stop aggrieved. He is before this court. Stop. Mr. G. Pegu, learned standing counsel. Elementary.
Yeah.
Submits that departmental proceeding against the petition is already initiated, and moreover, CID investigation is also being carried out. And therefore, the prayer of the petitioner is premature at this stage. Stop. In support of his submission, he refers to the second part of paragraph 12 of the affidavit opposition filed by the respondent number 2. You're Mr. Talukdar.
S. Sharma.
I'm sorry, Mr. S. Sharma, learned counsel for the petitioner, on the other hand, submits that the petitioner is not aware about any such departmental proceeding drawn against him, in view of the fact that no charge sheet has been furnished to him till date. Stop. Such being the position, and taking note of the fact that the affidavit of position was filed way back on 19/6/2024, Mr. G. Pegu, SC Elementary, shall obtain instructions as to how the departmental proceeding is being initiated and what is the stage, by producing relevant documents. Stop. He shall also obtain instructions with regard to the so-called CID investigation being carried out, and inform the court about the status by the next court date. Stop. List the matter again on so and so. When can you do it?
I have some urgency in this matter, my lord, because the person is going to retire
When?
next year. Next
When?
year,
Next year, June.
lordship,
June next year. That's what you said last time.
lordship.
Will not take long time. You don't take a long time. When can you get it? Okay, then on 4th or 6th November? 6th November. List again on 6th November 2025.
Apply.
Mr.
S. Bishop.
HK.
S. Bishop. S.
Mr. S. Kashyap, learned counsel, appears for respondent number 3. And Miss A. Bukan appears for respondent number 6 and 7.
Apply.
My lord, in item 6, my lord, which is time being, my lord, may I play one thing, my lord? My lord, the petitioner just now informed me, the director called him to her office to issue some order, my lord.
Who?
The contemner, my lord.
Which case?
In 6, my lord. Time
Six.
being,
6 and 8,
6, my lord, I am for 6, my lord.
only for 6.
For 6, my lord. So petitioner is called by the contemner, my lord, to her office to issue some order, my lord, provincialization order. So, my lord, can it be, may I pray on, can it be taken out 22, my lord? Perhaps they may comply today, my lord. So,
23,
yes, my lord.
Mr. M.R. Khandakar, learned counsel for the petitioner, submits that the petitioner has been asked to appear before the director of which school?
Elementary.
Elementary education. And therefore submits that there is a possibility of the order of the court being complied with. And as such, the matter may be adjourned. Stop considering the submission, list this matter on 23rd October.
I am the.
No. Lordship, I pray this matter be kindly be passed over for the time being. Mr. S. That the senior counsel is on legs in court number 1. He will be leading me in this case. Just for the time being.
Who's there for the other thing?
I'm
You were there?
Yes, I'm agree.
Are you ready with the case? Mr. Sharma,
Yes, ma'am.
are you ready with the case?
We have already filed our affidavit here, madam.
Okay, very good. Filing affidavit is one thing, being ready is another thing.
Yes.
Are you both?
So, my lord, on next week, my lord,
My lord, this person is going to retire on 31st of October. Her pensionary benefits will stop if the leave is not granted.
No, he's retiring on.
31st of October.
Okay, what is the prayer here?
The prayer here is to grant of extraordinary leave for the period of 345 days. Now, what has happened, Lordship? During her tenure, she has joined services in 94. During tenure from the period from 1/9/2006 till 30/11/2006, and thereafter some more days, she has gone to leave which were not accorded sanction at that time. So she made a prayer in the year 2015, but those representations were never disposed of. At a later stage, Your Honor, she filed an writ petition. If Your Honor kindly sees page number 32 of the writ petition, Annexure 8. This is the operative portion.
This is the second round.
Second round.
What was the grievance in the first
The
round?
grievance was the same, but at that time, the representation, the court had ordered that without going into the aspect as to whether the representations were submitted or not, and whether it was received or not, we require the petitioner to submit a fresh representation making her claim.
Okay, just a minute. You read paragraph 2 before that. Paragraph
Right.
2.
No. Paragraph.
Mr. Datta,
Yes, I'm sorry, my lord, I got.
you are free now?
Yes, yes.
Okay, I was just trying to understand the first round.
The first round was that, my lord.
Please read this paragraph 2 for me.
Yes.
Page 31.
The petitioner is a postgraduate teacher in economics at so-and-so high school. There is an issue as regards the petitioner for not having granted her leave for the period so-and-so to so-and-so and from so-and-so. The petitioner claims to have submitted 2 representations before the Director of Secondary Education for redressal of her grievance as regards the regularization of the aforesaid leave period. Mr. So-and-so counsel for the Secondary Education Department contests the statement of the petitioner that representations have been submitted by stating that firstly, the representations were not annexed to the writ petition, and secondly, what is provided is only a tracking report of the postal department, which cannot substitute the actual representations. Be that as it may, without going into the aspect as to whether the representations were submitted or not, or whether it was received or not, we require the petitioner to submit a fresh representation making her claim that the aforesaid leave period be regularized. The representations be submitted within a period of 15 days from today. Upon the representation being submitted, the Director of Secondary Education to pass a reasoned order thereon within a period of 6 weeks from the date of receipt of the representation. Now,
Then when did you submit your representation?
then, my lord,
Next page.
the next page, page 33, the representation was submitted.
Why did you write judgment and order? This is not a judgment.
Perhaps it is because of a misunderstanding by the petitioner, my lord. It's an order. So it was submitted and the impugned order was passed at page 38, annexure 11.
Okay, 38.
8.
Okay, what does it say?
Now, it says the second paragraph, my lord.
Hmm.
In compliance of the order dated so-and-so passed by the Honorable High Court, a hearing was held wherein the petitioner could not produce proper medical certificate duly approved by the medical board in support of her claim to grant extraordinary leave for the aforesaid period.
Hmm.
And on this reasoning, my lord, my application for regularization of leave was rejected.
How many days are there in all?
My lord, in all, it will be 345 days. We are not more.
1/9/2006 to 30/11.
Yes.
Then
There are different
91 days.
There are different spells, my lord. In total, it will come to 345 days.
What kind of leave did you take otherwise?
My lord, I had asked for grant of extraordinary leave.
No, no. Why you were absent on those days?
My lord, the few period were on the ground of my illness because of TB. Initially, that leave was regularized. Page 19, your lordship may kindly see.
So total is 91 plus 18 plus 11. Number
Yes.
of days.
Yes, plus 225. The last spell of leave was 225.
Huh? Where is that? Okay, 225.
Yes,
Oh, so 225.
225,
That
11,
means-
18 and 91.
That means 345 days.
345 days
All in all.
in all.
So how did you proceed on leave like that without
My lord,
leave being granted?
my lord, as it appears from the records, I submitted leave applications to my principal of the school. And I proceeded on leave. Principal appears to have forwarded those to the IS, that is Inspector of Schools. But those were not attended to for a variety of reasons. And ultimately, my lord, the realization came late on the part of the petitioner, my lord. She is retiring on 31st of this month. So when the process
See-
of drawing the pension papers came, my lord, then
No, Mr. Datta, that comes later on. What I don't understand is you write an application for leave, you drop it in the box and you proceed for leave
no,
without waiting
No.
for an answer whether it's granted or not.
No,
Does it work like that?
my lord, it was all on medical emergencies. First, I was suffering from TB. Secondly, my lord, there were some gynecological problem, my lord, about which, my lord, the disclosures have been made in the petition itself and the annexure. And I submitted the application to my immediate higher up authority, who is the principal. Now, on submitting the leave application to the principal in his turn, he forwards it to the IS.
Who is the granting authority for leave? Not the principal cannot grant.
No,
IS will grant.
yes.
Or director.
Extraordinary leave, my lord, it was the IS.
IS.
It was the IS. Principal is my immediate controlling authority, my lord.
No.
Administrative authority.
You applied for what kind of leave? Extraordinary leave.
Initially, I applied for extraordinary leave, but later I realized that for TB patients, my lord, there is a office memorandum of the government which allows the TB patients to go on leave without any leave being debited to from the leave credit. So thereafter, I made a request that this period of absence on the ground of TB illness, my lord, that may be, although it was granted under extraordinary leave, that may be the benefit of that circular may be given.
How
But
many
in-
days?
That was for 18 months. That was 180 days, but they did not grant me the benefit of the office memorandum. They instead granted me extraordinary leave for 180 days initially. Thereafter, my lord, my illness continued, and that's why, my lord, the different spells, 91 days, 18 days, and 11 days, this kind of things appeared.
After deducting 180 days. 180 days.
Yes, yes, after deducting 180 days,
180 days, 345 days still remains.
still remains. Now-
It's almost 1 year.
Almost 1 year. Now, under the leave rules, my lord, I can have a leave of 300 up to 360 days. In I mean, combination of the variety of leaves that are available to a part, like casual leave, earned leave, half pay leave, etc. And in total of my service career, one is entitled to about 5 years of leave, maximum. That is the maximum usually. So I am otherwise, even the respondents have filed an affidavit, my lord, indicating my leave ledger. On their own showing, my lord, in the leave ledger, there is leave available to me. They have filed an affidavit. Your lordship may kindly see page 55. It is a leave ledger. According to them, my lord, it is the ledger of the leave account.
$55.
Yes. 55 is their affidavit, my lord. It's a ledger account, leave account, which has been submitted by them. Now, this also indicates that, my lord, there is leave in my credit.
Where?
Now,
How-
if your lordship will kindly see the column 8. Now, column 8 is the collection of the leave that I have asked for. I mean, from time to time, well, from column 1 to 5 is the accumulation of the leave. From column 6 and 8, Miller takes into account the leave I have availed and the balance in my credit. And the total comes to, Miller, I did the arithmetic, Miller, it comes to 576, well, subject to correction.
No, where is that balance?
Miller, balance is indicated in the column number 8. Sorry, column number 9.
9, but there's nothing written in column number 9.
No, if your lordship will, I just did the arithmetic, Miller, subject to corrections. If your lordship adds the date on column 8, I mean the number of days in column 8.
All the number of days.
All the number of days in column 8 and subtracts it from the number of days available in column 5, then, Miller, the balance comes. Column 5 is the accumulation over a period of time.
No, what is the column 5?
Column 5 is leave at credit in days. Columns 9 plus 4 subject in appropriate limit. And this leave account is only up to the year 2011. This is 2025. From 2012 to 2025, there was not a single instance where I had availed leave. Not even any earned leave or casual leave, any leave. So
95 to 2011.
From 2012 to till 2025, my lord, I did not avail any kind of leave.
See, the stand taken in the impugn order is not that you don't have that much leave in your credit. It says that your medical certificate
now
don't have anything in support
Yes,
of your
now-
contention that you are not well.
Now, first of all, my lord, the medical certificates were submitted at the initial point of time. Your lordship can, even they admit it, my lord. In their affidavit, they have enclosed the letter written by the
Initial point of time, how can you just rely upon that initial submission for all time to come?
No, I am not saying that, my lord. What I am on, leave rules also permit me to be granted leave without production of medical documents.
No,
That is also possible.
yeah, possible maybe, but
That is also possible. And
since you are saying that you have taken leave because of your ill health,
yes, now
is it not required of you at least to satisfy the authorities that these are the documents?
now
This is how I have suffered.
Now, one document, my lord, they have enclosed to their affidavit in opposition, page 52. It is their document where the principal forwarded my leave application along with the medical records to the director of secondary education.
No, this is already in 2015
Yes.
when
My lord-
you had come to this court earlier.
My lord, my entire period of duration of leave is up to 31st of March 2012. Entire duration of leave was up to 31st of March 2012. Now, after 2015, my lord, if they now say that I require the documents once again, where from, my lord, shall I? That's why, my lord, in one of the proceedings, my lord, I made a submission before the Honorable Court that I am ready to forego even the salary. Even the salary, I am ready to forego for that period.
No, that's a different aspect, Mr. Counsel. You see, unless you satisfy the authorities that you had taken that leave without waiting for the leave to be sanctioned, because of your medical condition, the least you can do is, you should do is at least provide them the material that this is their thing.
Now, my lord, at this.
That means you don't have any medical documents and
No.
simply you are asking regularization.
No, my lord, medical documents were submitted. If your lordship will kindly see this particular annexure in the writ petition as well as in the affidavit in opposition filed by the respondents, my lord. If your lordship will kindly come to page 22. The typed copy is at page 21. And then page 23.
Where is your relief application? This is only a forwarding.
My application, your lordship may kindly see at page 18. And the benefit of the office memorandum that I had asked for was at page 19. This office memorandum says that regardless of the situation, I mean, on availability of leave, I am entitled to 18 months leave under if I am suffering from TB. And it's a fact not. Because at one point of time, they had allowed me leave from 1st January 2006 to 30th June 2006, 180 days. They granted me extraordinary leave on this count.
Mr. Datta, page 18 is basically seeking conversion of your leave
Yes, that
granted to you by way of extraordinary
Yes,
leave
yes.
into a leave admissible to be a TB patient.
Yes.
So that your leave credit, does not get deducted.
Yes.
But thereafter, what is the subsequent leave that you have sought for? What has happened to that?
My lord, those were disputed by them in the previous rounds of litigation. That's why Honorable Court said that submit a fresh application. Now, the fresh application I submitted, that I have just.
Where is your fresh application?
That is at page 33, and the format that I filled up, they require me to submit the application in a format. They have enclosed the format that is at page 54. So after the order of the Honorable Court, my lord.
What have you enclosed in your application?
Well, that is the problem, my lord. Problem is this, my lord, after 10 years now, where from shall I have access to the records? Records I had already submitted to them. And the fact that those things were submitted, I submitted the postal track record, which the Honorable Court said that we are not going into the matter whether the postal tracking is.
No, please come to page 36. You yourself have written enclosed as above. What did you enclose?
Page 36. Yes, the medical documents, and they disputed that this document in support of this, my lord.
Where is that medical document?
Well, lord, in support of this, I submitted.
Where have you stated that medical document?
No, it is not stated here, but
It simply says enclosed as above. So I want to know what is that enclosure?
Well, my lord, most probably it will be the documents at page 40 and.
Please come to page 34.
39 and 40.
Now, please come to page 34. The first paragraph, inner page 2.
Yes, a matter of.
You have mentioned about Schedule A below.
Yes, and which I filed on so and so. Again, I have enclosed here with copies of medical certificates of which the original medical certificates were submitted on earlier occasions.
Okay, that you have not enclosed in this writ petition, isn't it?
No, my lord, the page 39 and 40, your lordship may kindly see. This is one of the certificates that was available with me, which I could enclose in the writ petition. And basically, my later part of my illness, my lord, that is the gynecological problem about which, my lord, there is a disclosure in this certificate.
With this kind of problem, you have been advised to take rest from 28/2011 to 31/3/2012.
This is one of the,
9, 10, 11, 12, 1, 2, 3, 7 months.
yes. That is one of the issues, my lord. My lord, I cannot comment on this, my lord.
I'm not even commenting on it, but I'm just expressing surprise. That tomorrow you say that I've got headache and you take rest for 7 months. See?
My lord, ultimately
David?
the issue boils down to this. Number one, that is my respectful submission, my lord. Number one, whether I have leave in my credit, whether that can be allowed to me. Number two, if I do not have any leave at my credit, whether extraordinary leave can be granted. That is the issue. That is the call the respondents are required to take. They are insisting on the production of medical certificate from the year 10 years in the past. But that becomes a impossibility on my part, my lord, to procure. Who will give me a certificate from those period now? And
Have you said that anywhere in your representation that
no,
these are all the documents I have? Beside these documents, I have already submitted most of my medical documents.
my lord, page,
My application dated so and so, so and so, so and so.
my lord, page 34, there is a reference that I submitted all those documents previously. Page 34, the top paragraph. And therefore, my lord, the Honorable Court took a very pragmatic view of the matter that regardless of whether you submitted or not submitted, you do it afresh. You submit a representation for consideration of your prayer for regularization of leave. That was the order of the Honorable Court. And my respectful submission before the Honorable Court was that since there is leave in my credit, there are circulars issued by the government allowing me to conversion of my leave from one kind to another. They should take a pragmatic call on it. And I went to the extreme of making a submission that even I can forego my salary for the period. Because unless and until, my lord, this period is regularized, my pension will be held up. From next month, I will not get anything.
So that is your story.
That
Mr.
is
Sharma.
the case, my lord. And the rules, my lord, if your lordship wants, my lord, I can place the rules. Rules provide that I can be granted leave even without production of medical records. Assuming for a moment that, my lord, although the representation says that I had submitted the medical documents to them, assuming for a moment that, my lord, I did not submit medical documents. Question is whether or not I can be granted leave on that count. Rules say that even without production of the medical documents, my lord, I can.
So, which rule?
Well, extraordinary rule 14 of leave rules, state leave rules, my lord. Huh? Copy. Well, lord, if your lordship permits me to exchange this, my lord, this is from their department's website only.
This is a photocopy.
Well, lord, it is downloaded from the state government's website. If your lordship can come at page 8, my lord, it says about grant of extraordinary leave, my lord, to up to a maximum period of 5 years. Page 8, your lordship may see the entry 5. Extraordinary leave is neither earned nor accounted for separately. It is granted when no other leave is admissible or when the employee asks for it. Periods of absence can be regularized by grant of extraordinary leave extraordinary leave can be availed either on medical certificate or without medical certificate. There is no maximum limit for permanent employee except the overall limit of 5 years for all kinds of leave together.
So how many years have you taken leave?
No, I am
Altogether.
altogether, my lord, this, if you're, huh? Till 2011, my lord, if this period is taken into account, it will be 576. Till 2011. After 2011, I have not taken a single day of leave.
Your leave was up till 2011.
The regularization which I am asking for, my lord, that is up to the year of 2012, 31st of March 2012. Thereafter, not for a single day have I taken a leave. And in the entire period, my lord, the total number of leave will be around 576 days.
No. Entire period is something else. Now you're saying that you have not taken any leave after 2011.
2012, 31st March 2012.
How do you say that?
My lord, that is, I have not taken, nor have they said that I have taken any leave thereafter. And the ledger account, leave account which they have submitted, that is up to 2011.
Where is your statement that you have not taken leave from 31st March?
It will be visible from this leave account ledger only, my lord.
No, this leave account visible is only, this is only one page, okay?
Yes,
And,
this has been, it has to be produced by them, my lord, because they maintain the leave account.
No, you also should know how much leave you have taken.
Well, I am saying that the leave account which is indicated in the leave ledger, my lord, that is the amount of leave that I have taken till now.
This is just one page, okay? It starts from 90. When did you start your service?
95.
95. 95 to 2011, there is a leave account is there.
Yes.
Now you are still in service.
I am still in service and
retiring in
31st this
2025.
month.
So 2011 September to 31st of October 2025. In between, you mean to say you have not taken even one single leave also?
So my last
Because it is not shown in this page.
It is not only because it is not showing here, my lord. My last application for leave is for the period from 20th August 2011 to 31st of March 2012, which they have not taken into account.
20th
August 2011 to 31st of March 2012. This is the largest chunk, my lord, 225 days. That is also not indicated in the leave account. But beyond that, my lord, I have not taken a single day. Oh, I'm sorry, my lord, it is indicated here. In column 8, there is an indication, my lord, 225 days. In column 8, it is indicated 220. That is the largest chunk. Had I taken leave, it would have been reflected here.
Under column 8, under column 9, you will see the last 8, in fact, it's 8. Under column 8,
yes,
from the period starting from 30/6/2006 to 31/8/2006. And the remarks given and against column 8 is unauthorized absent, unauthorized absent, unauthorized absent. 1, 2, 3, 4 on 4 occasions.
Yes.
91,
18, 11, 225. This is the period I am asking for regularization.
225.
These 4 spells I am asking for regularization.
By way of EOL.
By way of EOL. They can also grant me other leave if they so desire. Because if the other leave is at my credit.
And this EOL says what? Either certificate.
Because for EOL, my lord, there is no account maintained. It is discretion of the employer.
What is the benefit you get if you take EOL? You take full pay or half pay?
If I take EOL, my lord, my leave will not be disturbed. The leave credit will not be disturbed.
The extraordinary leave.
Yes.
It is granted on what ground?
Well, usually it is on There is also medical leave, but in medical leave, I get if there is medical leave in my credit, my lord, I get leave encashment for that.
Extraordinary leave, you get your salary, you get your pay
Yes.
while on leave.
But
And there's a half pay leave.
there is also a half pay
Then
leave.
leave without pay is also there.
Leave without pay is also there. If they want to adjust me, my lord, by exhausting my other leave available, they can do it. If they want to, that's why, my lord, I submitted once.
Leave without salary also.
Yes, without salary also I can, I am agreeable to it.
Okay.
That's why, my lord, there is, in one of the orders, my lord, it has been also reflected by the honorable court that I made a submission that I can forego the leave for this, the salary for this period.
What is this EOL you have given me? It's from the handbook.
Well, it's a handbook.
Leave
prepared-
rules.
Yes, handbook of leave rules prepared by the government of Assam,
This is for the state government.
state government.
You don't apply the CCS leave rules.
No, I'm a state government employee, my lord.
State government.
I'm state government employee.
Correct. But that state CCS leave rules
No,
is
that
not
is-
adopted.
No.
State has its own leave rules.
It's own leave rules.
Mr. Sharma,
My lord. My lord, after,
if he has leave in his credit, why don't you give him? Why?
my lord, in the chart itself stated here, my lord, in column number 9, my lord. Earlier, all these are extraordinary leave and thereafter 91 days. And it is from 1/9/2006 to 30/11/2006, 91 days is unauthorized absent. Thereafter, 1/8/2008 to 18/8/2008, 18 days unauthorized absent. And thereafter, 21/8/2009 to 31/8/2009, 11 days unauthorized absent. And then 28/2011 to 31/3/2012, 225 days unauthorized absent, my lord. And my lord, after filing the representation, a hearing was held. And at that hearing, the petitioner could not submit the proper medical certificate to prove her absence is genuine. And that she was under the medical treatment. Here it is stated, in the compliance of order dated 27/5/2022 passed by the Honorable High Court, a hearing was held wherein the petitioner could not produce proper medical certificate duly approved by medical board in support of her claim to grant extraordinary leave for the aforesaid period. And in this regard, my lord, we have also filed our affidavit here also.
Mr. Sharma,
My lord.
see, in some cases, when somebody is absent for 1 day or 2 days
Yes.
unauthorizedly, what do you do?
My lord, there is one aspect that the departmental proceedings is.
Ah. So have you drawn any proceeding in this case? Any whisper anywhere? We are going to draw departmental proceeding against this person because he has been unauthorizedly absent for 345 days.
Yes.
Is that your stand anywhere?
My lord, in our affidavit, there is no such type of statement here. my lord.
Then
So
what do
regarding,
you intend to do about the unauthorized absence? You don't want to draw any proceeding. Neither do you want to draw a proceeding, nor you want to regularize that. You have to do something.
Well, possibly, well, it is my guesswork, Miller. Possibly they have not been saying about the disciplinary proceeding now, because in the Assam discipline and appeal rules, Miller, there is a bar that it cannot be related to a period prior 4 years prior to the date of retirement. Some instance of misconduct committed 4 years prior to the date of retirement. Possibly that bar is the reason, Miller.
Apart from that, I'm not giving you any ideas, Mr. Sharma. I'm just asking you, because one tends to think that can you put somebody in such a state in the middle?
So my lord,
Because
sometime I will
the,
get that-
not sometime, what sometime? For what?
so that I can take the clear instruction regarding that.
Regarding what?
Is there any proceedings already drawn or
No,
not?
no, you don't have any instruction. Don't give them ideas now. You will go and tell them now you draw proceeding. I'm not one that. It's up to you. You have to think, you have to figure it out yourself. You are the authority. There appears to be some element of acknowledgement about his difficulty, TB and whatnot. Although for certain simple ailment, has taken 7 days, 7 months break. Thing is that you see the person is retiring, so that problem will be there. Leave period will not be regularized, pension will not be given. And that trouble he'll have to face.
My lord, next week maybe.
Next week for what?
To get the instruction from
No,
the
no.
department, is there?
What instruction you'll get? You can simply reconsider this. I'm not saying that you regularize all his leave service. I'm saying that you verify whether he has got any leave to his credit. If so, you apply that. And petitioner also is agreeable that even in the extreme cases, he may also go without pay, leave without pay. To that extent also is agreeable. Because if I found any element of you taking some disciplinary measure, court will not stand in the way. But since there's nothing, then simply saying that you don't have medical certificate, so will not do anything, cannot be the answer. And tomorrow you take instructions, they will have some other ideas saying that this is what we're going to do now. That also will not be the best thing. Taking all this into account, you reconsider. I'll record your submission also,
Yes,
Mr. Datta.
My lord, that is already recorded in the order sheet, my lord.
No, we'll record it once more.
Yes.
Please write down Heart Mr.
Yes.
S. Datta, Learned Counsel, Learned Senior Counsel, assisted by Mr. P. Sengupta for the petitioner, and also Mr. U. Sharma, Learned Standing Counsel. This is what, secondary education department. Mr. Sharma, you sit down and relax. Why are you reading all these things now? Next para. This is the second time the petitioner is before this court. Stop. The earlier writ petition being WPC number 3460 of 2022 was disposed of by order dated 27/5/2022. By directing the petitioner to submit a fresh representation for making a claim for regularization of her leave period, oblique period of absence. Stop. The petitioner accordingly submitted her representation, but the same came to be rejected by the impugn order dated 27/6/2023, bracket annexure 11, on the ground that the petitioner could not produce proper medical certificate duly approved by the medical board in support of our claim to be granted extraordinary leave for the period concerned. Stop agree if the petitioner is again before this court. Stop next para. Mr. S. Datta, Learned Senior Counsel, submits that the petitioner had submitted all her medical certificates and related documents at the initial time. When did you submit? At initial?
That is not very, the date is not very sure, but in the page 33, Millard, 34, Millard, it is indicated to be sometimes in the year 2022. Oh, it was submitted through some site. They have some site probably.
Had submitted her documents and medical documents along with her application filed on 16/3/2022. Stop. Nevertheless, she also submitted a certificate issued by the medical officer. S.K. Roy Civil Hospital, Hailakandi, along with her representation dated 7/6/2022. Stop. The respondent authority concerned, however, did not accept the application for grant of extraordinary leave for the period concerned for want of medical documents. Stop. Referring to the leave rules of the state government, more particularly what do we call this rule? Rule
5 probably.
Rule 5.
Yes, they identify it as Leave Rules 34, Leave Rules 1934. And in the handbook, Millard, your lordship will find the entry 5.
This again is from FR.
The FR 58 is the source, Millard.
FRSR is central, isn't it?
No, the state also has a.
State also has.
Yes. Millard.
What did I say?
Millard, this is the state's FR, it will be FR 85A speaks about the extraordinary leave.
From where are you saying that?
Millard, I'm passing on the leave, I mean the leave rules. Lordship may kindly look into this book. FR 85 says about this, Millard.
My lord, may I interfere one, my lord? May I submit one thing, my lord? My lord, I have received one instruction here, my lord, and as per instruction, it is stated that Directorate even could not trace her representation for granting her leave, which is supposed to be submitted by the petitioner as per the order of the Honorable Guwahati High Court. Conclusion. Based on the above findings, it is not possible to grant extraordinary leave on medical ground to the petitioner, Srimati Triveni Bora. However, the said absent period may be treated as no work, no pay under FR 17(1), and absent period may be treated as on duty only for pensionary purpose. This is my instruction.
Why did you keep that in your closet?
No,
Huh? All the time you were arguing and you are not keeping that document in with you, safe and sound where somewhere.
If it is with them, my lord, it clinches my case.
So they say that it can be counted for pension, then your worry is over.
Yes. Well, your lordship may record that, my lord, and
More particularly, what is this? FR 85 bracket small a, which
copy আছে নাকি?
provides that extraordinary leave can be granted on special circumstances when no other leave is admissible. Stop the learned counsel, senior counsel also submits that extraordinary leave can be availed either on medical grounds, either on medical certificate or without medical certificate. Except that the overall limit of 5 years for all kinds of leave is the maximum ceiling. Stop. He therefore submits that the rejection made by the respondent authority concerned should be interfered with by this court. And the petitioner should be the absent period should be regularized by grant of extraordinary leave. Stop. The Learned Senior Counsel also submits that the petitioner also does not have any objection if the leave period is regularized without pay being granted. Next para, Mr. S. Sharma, Learned Standing Counsel.
It's a huge honor.
Huh?
Huge honor.
Oh, U. Sharma, Learned Standing Counsel. Secondary Education. Where is the document?
From the top fourth paragraph.
Where?
From the top fourth paragraph, my lord. As per hearing report, copy and close, it was concluded that it is not possible to grant extraordinary leave on medical ground to the petitioner, Srimati Triveni Bora. However, the said period may be treated as no work, no pay under FR 17(1), and absent may be treated as on duty only for pensionary purpose.
Submits that the respondents have made their stand in the counter affidavit.
Well, it is possibly in their instructions. Your lordship may mark it as part of the record. But this is in their instructions, my lord.
I know. First of all, I'm indicating the counter affidavit.
Yes.
What did I say last time? No, it comes right like this. The respondent number 4 has filed the counter affidavit. Respondent number 4 within bracket, Inspector of Schools, NDC, Nagaon. Stating that whatever was forwarded by the principal of Motiram Bora High School, is it? High school or high secondary?
Higher secondary.
They write HS Balika.
Higher secondary.
HS means high secondary.
Higher secondary.
It can be high school also.
No, I see.
No, higher secondary.
Okay, Motiram Bora High Secondary, Balika Vidyapit, Nagaon. Covering a total period of 345 days. Was forwarded to the Inspector of Schools. And that therefore, the respondent number 4 has played its role. So the said affidavit does not, however, state as to why the leave period has not been regularized as permissible in law. Stop at this stage. Mr. U. Sharma, Lanet Standing Counsel, has produced the instructions received from the Director of Secondary Education dated 13/8/2025. And the relevant portion of the instruction is being abstracted here under. Please abstract A to A. This red flag, okay? A to A. Next para, from the above abstract, it may be seen that a hearing was conducted, and as per the report, it was found that grant of extraordinary leave on medical ground was not possible. And the said period should therefore be treated as no work, no pay under FR 17(1). And the period of absence may be treated as on duty for only for pensionary purpose. To stop. As submitted by the learned senior counsel for the petitioner, the petitioner also agrees to forego her pay. Is due to retire on 31st, is it?
Yes, sir. 31st this month.
Of October 2025. The respondents in terms of the above instruction should act upon the same by regularizing the period of absence.
Leon pensionary purpose.
In terms of, I say, nothing else is there. So that the petitioner okay. Okay, what did I say? Just read in terms of. Hmm. Be- by regulating the period of absence. By treating the absent period as on duty for the purpose of pension. Anything else?
Well, my pension papers may therefore be processed.
And that is not your prayer.
That is not my prayer, but my lord, as a consequence of this, my lord.
No. That they will do it. Then
The annexure may be kept on record. I mean, the instruction may be made part of the record.
Thank you. It needless to say, the impugn order dated 27/6/2023. So stands interfered with. The petition stands disposed of.
Well, the instructions may be made part of the
The
record.
instruction produced by the Learned Standing Council shall be kept on record and marked as 6 for identification. This is the one, okay? A to A. This was item number. Now, who was that counsel who was supposed to come? That time being matter?
And they Khatami.
Where is he? Is he coming? Have you informed him?
I will inform.
Please inform him, okay?
Yeah, Malad, I'm seeking some time on behalf of Mr. B. Kaushik Malad. Though my name is also there in the cause list, but Mr. Kaushik is exclusively handling the case, Malad. Due to some medical emergency, he is not available. So Malad may take it up immediately after Diwali vacation, Malad.
Who will be appearing? Kaushik or yourself?
Mr. Kaushik, Malad.
Morning, I was told it was you who appeared.
It was Malad, he was not aware of that, Malad. Mr. Sharma, he was not aware of that. In item 7, I was appearing, Malad. In item 8, Mr. Kaushik is appearing, Malad.
Anyway, whoever is appearing, or what I'm interested to know is what steps you have taken. That you must inform.
It's not on reopening, Malad, after the Diwali vacation, because file is also not with me, Malad. If he is not available, Malad, I will obtain the file and
No, file is with not me. Can I also say that file is not with me today? I have not read the file. You come day after tomorrow.
No, Malad, I'm sorry, Malad.
Does the court say that?
No, Malad.
We don't say that, isn't
No,
it?
Malad.
Whatever the council says, okay, we agree.
Yes, Malad.
But today I'm requesting you
Yes, Malad.
that this is a serious matter. You see, few orders are passed now and then.
Yes, Malad.
Nothing has been done. It's not just that.
In fact,
was yesterday. This order was passed quite some time back.
Before Puja vacation, Malad. They are supposed to submit a group certificate they have submitted in the last occasion, my lord. So then matter is fixed for today. As directed by this honorable court, they have produced the age proof certificate.
Who is the counsel for the petitioner who appeared this morning?
Mr. D. Gogoi.
Mr. D. Gogoi, learned, please write down. Mr. D. Gogoi, learned counsel appears for the petitioner. And Mr. N.J. Kotonia, learned counsel appears and submits that Mr. B. Kaushik is handling the matter. And since he has some personal problem, he cannot appear before the court today. He therefore seeks that matter be listed. When?
After Diwali, my lord, on 22nd, my lord. Or 24th.
After a week. Full stop. Next, Kara. By filing this contempt petition, the petitioner alleges non-compliance of the order dated 21/6/2024, passed by this court in WPC number 925 of 2024, whereby the Director of Secondary Education was directed to allow the petitioner to function as headmistress of the school concerned. So the director has filed an affidavit, and at paragraph number 9, she has sought to justify that Rule 12 of the Assam Secondary Education Provincialized School Rules 2018 provides for certain criteria. Stop, since the set criteria is not met by the petitioner, the respondent is in the process of considering please cancel that part. Respondent is considering. Since the above criteria appears to be not met with by the petitioner, a report is being sought from the Inspector of Schools, Sivsagar. With regard to the upgradation for the post of headmaster to the post of principal, after the high school is upgraded to higher secondary school, next para. It may, however, be seen that the direction passed by this court on 21/6/2024 has not been questioned by the authorities concerned by filing necessary process, and therefore it would not be open for them to not comply with the direction by giving some justification. Stop, since Mr. B. Kaushik is not present today, let the matter be listed again on 24th of October, 2025.
So be second. So be second.
24th, Your Worship.
24th.
Yes.
How will it? Take it over.
What about 6? 6 is done.
May it please your lordship. Your lordship, I am appearing on behalf of my senior, Mr. A.K. Bhuya, who has been recently appointed as the Senior Study Council for BTC. As there are no available copies of documents with us, we request the honorable court to make for adjournment of this matter in the next 2 weeks.
So change of hands. You don't get the briefs. The previous councils will keep it with them. They don't want to part with it.
Your lordship, we haven't yet received any document from them.
You should ask them, we are the new councils, give us the copy.
It will take a little time, your lordship.
None appears for the petitioner when the matter is called. Stop. Miss
P. Kashyap.
P.
Kashyap.
Miss P. Kashyap, learned counsel submits that Mr.
A.K. Bhuya.
A.K. Bhuya is the newly appointed standing counsel for the
BTC.
BTC. And since they do not have the brief at the moment, she prays that the matter be listed after
After 2 weeks, in
2 weeks.
In the meantime, my lordship, let it be directed to the petitioners to furnish.
You do that. This is not our lookout that you'll be given. Tomorrow somebody else will appoint and again will say that give copy to so and so. Ask for a copy. There are all your colleagues, isn't it? What they will do with those copies?
She wants me to.
Okay. List again after 2 weeks.
Even lordship, those we are agreed lordship on first week of November lordship.
Yes, agreed to by the parties is the matter in the first week of October, November.
No, November. It probably 6th of November, my lord. Thursday.
Okay, 6th of November.
Obligation.
For hearing, okay? 6th of November for hearing.
Lordship, can this matter be taken up after 2 weeks, Lordship?
Why?
I need to file an additional affidavit to bring certain materials on record, Lordship.
What do you say?
My lordship, can
Okay.
it be my lordship on 30th of this month, 30?
I don't know.
After 2 weeks, Lordship.
Only thing is that
Parivana?
if your friend does not file the affidavit, then
Yeah,
again,
then-
same
On
problem.
4th, Lordship.
No, then it can be, my lordship, then can it be on, no, 6th, can it be on, yes, on 4th also will do, 4th November? 6 na lang.
Mr. D. Upamanya, learned counsel appearing for the state or department,
Higher Education Department.
appearing for the higher education department submits that he may be allowed to file an additional affidavit to bring on record. What do you want to bring on record?
The list, Lordship, of 354 candidates, Lordship, who were shortlisted, Lordship, in accordance with the OM, Lordship. So, Lordship, just
But we bring one list of the candidates, of 354 candidates on record, names of those persons.
Bring on record
certain materials.
the shortlisted candidates, which would be relevant for considering the instant case. On prayers allowed, list again on after
4th November, my lordship.
list on 4th November.
Obligement. Interim orders are there, my lordship. Interim orders are there.
Interim order passed earlier shall continue till the next date of listing.
Oblige, my lordship.
Lordship, my senior MK Sudhir is on legs, lordship.
So you argue,
Lordship,
Hmm?
Lordship, may I kindly pass over a matter for the
Lordship,
time
can it be
being?
taken after a week, Lordship? Even Lordship.
Why?
Mr. K. Gogoi is also appearing, Lordship. He is also Lordship. Today.
Diego was here.
Yes, Lordship, but Lordship, he's on another. This will take some time, Lordship.
You don't want to appear before the school?
No, Lord.
Hmm?
No, Lordship. He just appeared, Lord.
What is the matter?
Lordship, the matter is regarding the provincialization, Lordship.
Provincialization of the petitioner. What seems to be the problem? Somebody else has been provincialized. Private response is there? No. Not there. Mr. D. Upamanya, Learned Council, Standing Council, Higher Education Department, submits that he may be given some time to prepare the matter. Where is allowed? List again after a week. When?
10 days, Lordship.
List again after 2 weeks on a date to be fixed by the registry.
Highly applies.
Lordship, today I pray for disposal of the writ petition, Lordship, because on many occasions, Lordship, this matter has been adjourned. And Lordship, already, Lordship, the issue has been settled by this honorable court, Lordship. And exactly, Lordship, my case has
So
been
this is a covered case.
covered case, Lordship.
Okay, so nothing has to be done then. Covered case disposed.
Yes, Lordship, yes. No, my lord.
He's not agreeing.
Lordship, then let me place my case, Lordship.
What is a lengthy matter?
Lordship, before coming into the meritorious case, Lordship, may kindly see my judgment, Lordship, which I have placed before your Lordship. WPC 8694 of 2018, paragraph 6.
No, I want to understand the case.
Yes, yes.
Judgment will
Yes.
come later on.
Yes.
How many petitioner?
Lordship, 15, 15, total number 15 months.
$15.
One
five.
Lordship.
I think we should put on the AC, huh? Somebody put on the AC. It's pretty hot. This is regarding pension.
Yes, Lordship.
Okay.
Uh,
15 petitioners.
Lordship.
They are in service or no longer in service?
No, they are in service. Few of them have retired, Lordship. 3 or 4 have retired.
Who are
in the,
they?
In the mineral, Lordship.
Who has retired? Can you identify them?
Petitioner number 9, 10. Lordship, petitioner number, yes, 1, 3, 5, 9, and 10.
1, 3, 5, 9, and 10.
Lordship,
Retired.
retired. The others are in service.
Serving as what?
Serving as assistant teacher in ME and MB school. There was an advertisement, Lordship,
Assistant teacher.
assistant teacher,
Both ME and
both ME and MB.
what is MB?
MB, Lordship, it is up to class 8. Earlier it was class 7. Now it is class 8.
What is the full form of MV?
MB is middle school, Lordship. It's called middle school.
V stands for what? School? I don't think so. Huh? Vernacular.
Lordship,
ME is middle. ME E for what?
ME is middle English.
Middle English. MP is middle vernacular. Okay.
So, Lordship, there was an advertisement on Lordship 3/9/1991.
Have you annexed it?
Yes, I have annexed it. And in terms of the advertisement, there was a selection process. And in terms of the selection process, they were all appointed, Lordship. Your Lordship will find Lordship will find the advertisement at page
21.
Page 21.
But where's the date? You were talking about some date.
Yes, date was not there, Lordship.
Then?
I
From
put
the,
all-
from where have you imported the date?
Yeah. Then Lordship, my appointment letters may kindly be seen, Lordship.
No, you tell me from where have you imported the date?
Date, yes. Date, yes, date is written as 3/9/1991. It was the
Handwritten,
Yeah, handwritten, Lordship.
handwritten. This is from the newspaper or what?
Newspaper, Lordship.
Newspaper clipping.
Lordship.
So this was published in 3rd September.
3rd September 1991.
And the post is what? Assistant teacher.
Assistant teacher. Now, Lordship, page 2,
Just
college,
a minute. Assistant teacher, primary school,
primary school.
stipendary.
No, Lordship, it's simply assistant teacher in middle English and middle vernacular school.
Where is that? Serial number 2, bottom of the page.
Yes, Lordship.
But this is only, it says only with for middle.
Lordship, page 22 is relevant for me, Lordship.
Where? Where in page
Page
20?
22, Lordship, elementary education. We are under the elementary education. The second paragraph, Lordship, elementary name of the post, probable vacancies, minimum qualification, assistant teacher of 7606, primary schools, stipendary, science teachers for middle schools, assistant teacher, middle school. We fall into this category, Lordship. Third,
Serial number 3.
3, assistant teacher, middle schools.
Okay. Middle school.
Lordship.
So this is common for MV and ME
Lordship.
or what?
Yes.
It does not say so. It says only assistant teacher.
For MB schools, it is 5474.
Hmm.
And for Lordship, ME school, it is 7606. That is assistant teacher primary, the serial number 1.
But this primary school,
Primary school, yeah.
you never said primary, you said MV, ME. You said MV
Yeah.
and also ME.
Yes.
But now why do you go to primary school? Is it different?
It is written like this. Lordship.
Hmm? So confusion is there from the advertisement itself, or what?
Lordship, I'll come to that, Lordship. Later, Lordship. Lordship, may then you can see our appointment letters, annexure 2, College, Lordship. From page 23 to page 52. Onima Devi, BA pass, daughter and so is hereby appointed against the newly created post for assistant teacher of middle schools and allotted post to Central Boitamari MV School in the scale of pay 1185-2395 per month, plus other allowances under government rules. The post was originally created and allotted by government letters dated so and so. Thanks, sir.
See, the selection process took quite some time, or what? Advertisement was 91.
1991. Yeah.
Appointment came in 94 only.
1994 only.
After 3 years.
Yes. And Lordship, it is an admitted position, Lordship. In their affidavit, Lordship, by the director, they have in paragraph, Lordship, in paragraph 6, they have admitted that petitioners were selected by Subdivisional Selection Advisory Board in terms of advertisement and received monthly salary up to May 1995. This is a paragraph by the director, Lordship, at page 113. So there is no dispute that we are not selected. The director has admitted that we are selected. And we have also received salary up to May 1995.
Please go in sequence, in serially. Okay.
Lots. Paragraph, page 2, College, lots of our appointment letters.
All of them are in same date?
No, different dates.
Different dates.
Lots.
How many appointment orders have you annexed?
All lots.
All?
All lots.
Okay.
Then lots of annexure 3. It is the regularization order also. There are some lots of in between lots of there are some excess appointment made, and our selection and appointment were also subject to a screening by the Monoharan committee. After the screening committee lots of they found that our appointments were genuine And accordingly, Lordship, they passed this regulation order that is on 31/2006. May I read the regulation order, Lordship?
Read.
Yes. In exercise of the power conferred under the Director of Elementary Education Assam by the government under so and so, in pursuance of the government order memo number so and so issued on the decision of the cabinet meeting held on 24/2/2005 for regularization of services of 2276 numbers of LP, ME, MEM, SS, SSS teachers of the state who were appointed in excess of posts during the period 1/3/1991 to 30/11/1996, and which were inquired into by the one-man committee headed by Mr. S. Manoharan IAS and subsequently by task force district level screening committee, departmental screening committee, the services of 125 ME, MEM, MPs working teachers of Bongaigaon district are hereby regularized with effect from the date of their joining against the vacant post as per enclosed list received from the government in the scale of pay of rupees so and so plus per month plus other allowance as admissible under rules. It is hereby ordered that as per the letter of the finance budget department number so and so, the teachers regularized hereby shall furnish an undertaking along with the joining report as follows. I understand and accept that government servants joining the service of the state government on or after 1 February 2005 shall not be governed by the existing Assam Service Pension Rules 1962. It should be 1969. Typical mistake. An order issued under there from time to time, and their pension and other retirement benefits will be governed by a set of new pension rules which are being formulated in the line with the contributory pension scheme of the Government of India and going to be notified in due course. It is further ordered that without the above undertaking being furnished by the teachers regularized hereunder at the time of joining, no joining report shall be valid. Officials involved in the joining, drawing and disbursement shall therefore be responsible for any lapses caused in the process. Lordship, in the list, Lordship, next page 54.
No, before you go to the next page.
Yeah.
This undertaking.
Yes. Under compelling situation, Lordship, some of
No,
us have to give the undertaking.
maybe.
Yes.
This undertaking says.
Yes.
I understand that those who have joined after 1/2/2005
Lordship.
shall be governed by the new pension rules and not by the existing 1969 pension rules.
Yes.
So this is undertaking which you are supposed to submit.
Yes.
And of course, ultimately, you're going to say that I'm covered by 69, not new
Yes.
rules.
Yes.
So let us be clear about this.
Yes.
Okay,
Yes.
then next.
Well, Lordship, this our names we also will find at page 54. On Onima Devi, I have tick mark, Lordship. 13.
All right, names are there,
Names are
15 of them.
yes.
Now, those who retired now, what has happened to them?
They are not been they are subjected to, Lordship, the NPS laws.
Okay, any order by this court? Interim order?
No, Lordship.
That's subject to the outcome like that, nothing?
No, nothing.
Not there, no? Okay.
Then Annexure 4 Collie is your service book, Lordship. And Annexure 4 Collie, Lordship, may kindly see page 59. Date of joining 28/2/1994. Page 59, Lordship. The petitioner number 1, Annexure 4 Collie, page 59. Your Lordship, you will find at page 59 my date of joining as 28/2/1994. Just to show our appointment dates, we have given the service book, Lordship. The extract of the service book.
28/2/1994.
Lordship.
How is that?
Our appointment, Lordship.
No, how is that possible? You were appointed in 2006.
No. Our initial appointment is our regularization has been done in 2006.
Okay, regularization.
Yes.
Okay.
Lordship, Annexure 2 Collie, page 23. My appointment was 28 February 1994. And this has been reflected in the service book also at page 59.
So you're going by the date of appointment.
Yes.
All right.
And Lordship, Annexure 5, Lordship, we have basically challenged this office memorandum. Introduction of new defined contributory pension scheme. Page 105.
Page
105. Annexure 5.
This becomes effective from 1/2/2005, is it?
To be notified.
Huh?
To be notified, Lordship, on or after.
The scheme would be applicable to all new entrants
Yes.
joining state government service on regular basis against vacancy sanction posts
Lordship.
on or after 1/2/2005.
So we are all appointed in the year 1994. Also, our entire past service cannot be wiped out. That is our case, Lordship. And Lordship, we have also annexed one order passed by this honorable court in respect of Koilas Kolta versus State of Assam. That is, in that case also, Lordship, she was subject to initially NPS, then she was given OPS, Lordship, old pension.
Let us see that order.
Lordship.
Please read the paragraph 2.
In the case of the petitioner, that although the petitioner was duly selected as per select list published in the year 2001, but for inexplicable reasons, the petitioner was not given appointment, and it happened that even the candidates below the petitioner were given appointment pursuant to the select list of the year 2001. So that particular person was deprived, and ultimately, Lordship, he was given the pension under the old pension rules.
No, continue reading.
Continue.
Being aggrieved.
Being aggrieved, the petitioner preferred the writ petition before his court, being WPC 5509 of 2001. In the said writ petition, this court, by its judgment order dated 15/12/2005, had arrived at a conclusion that the respondent authorities has resorted to arbitrary action by appointing the candidates with lesser marks than that of the petitioner, even to the extent that the candidates whose name did not appear in the said select list were also appointed. Accordingly, by the said judgment and order, this court directed the respondent authorities, particularly respondent number 2, being the director of secondary education, to appoint the petitioner as assistant teacher in any high school in the Kamrup district. Pursuant to the said judgment and order of this court dated 15/12/2005, the inspector of schools by order dated 20/2/2007, by referring to the judgment and order of this court, had appointed the petitioner as an assistant teacher in Bani Vidyapit SS School, Sanmaguri, in the district of Kamrup, with effect from the date of his joining in the post. The said appointment order also provided that the petitioner will have to furnish an undertaking before joining in the school, to the extent that the petitioner would be bound by the new pension rules, which had been framed by the respondent authorities in the meanwhile. Pursuant to such appointment order, the petitioner had duly joined in service in the year 2007. In this writ petition, the petitioner assails the aforesaid condition imposed in the appointment order dated 20/2/2007, to that effect that the petitioner would be bound by the new pension rules. Consequently, the petitioner also assails the new defined contributory pension scheme 2009, which inter alia provides that all government servants whose services will be regularized against regular posts on or after 1/2/2005 shall be governed by the said new defined contributory pension scheme 2009. Further, the said scheme of 2009 also provides that all such teaching and non-teaching employees of provincialized educational institutes who had joined the said government service on or after 1/2/2005 shall come under the purview of the said scheme of 2009. The petitioner also assails the office memorandum dated 6/10/2009, which inter alia provides that the existing provisions of defined contribution, pension, and GPF would not be applicable to the new government servants joining the government services on or after 1/2/2005. Further, the petitioner also assails the letter dated 23/2009 of the officer on special duty of the government of Assam in the Finance Budget Department, which again provides that the state government employees joining government services on or after 1/2/2005 will be required to provide the required particulars in the prescribed format in quadruplet, which again is relatable to the new pension scheme of 2009. The issue of determination in this writ petition is that the petitioner, having been duly selected by the select list of 2001, and all other persons selected in the said select list having been already appointed in the year 2001, and the case of the petitioner having been left out illegally and in an arbitrary manner from being appointed in the year 2001, as already being held by this court in his judgment and order dated 15/12/2005 in WPC 5509/2001, whereas the petitioner would be governed by the old pension rules which were in force in the year
Okay,
2000.
Mr. Counsel, I have read it.
Yes.
Now, has it been challenged, this order?
No.
Not challenged.
Not challenged.
The only thing is, the facts in this case was that in 2001, selection was done. Somebody was missed out.
Missed out.
And later on in 2007, they gave him that appointment, but giving him putting him in the new pension.
pension.
So court said that no.
Yes.
Two different laws cannot be applied. So person appointed 2001 and person appointed 2007,
Yes.
although was to be appointed 2001, appointed 2007, should be governed by the same law and given the same benefit. So
Yes.
that is the judgment.
That is the judgment.
No appeal.
No appeal.
Okay. And your case today is that you are appointed in 1994.
93, 90, yes. Most of
1994.
93 and 94.
So
Our
even
regularization was done in 2006.
regularization came in 2006.
6.
And wherein you were asked to give an undertaking.
Lots.
So that cannot be binding upon you.
Lots.
Because your earlier point of service should also be counted.
Lots. Lordship may kindly come to the Lordship, the affidavit filed by the director, Lordship. Just one paragraph I would like to show, Lordship.
2006.
Yes.
Now, but this writ petition, when was it filed? 2022.
22, Lordship. In the affidavit of the director, Lordship, in paragraph 6, Lordship, they have admitted that as per report of the District Elementary Education Officer, Bongaigaon, had letter number so and so dated 19/7/2022. The petitioners were appointed during 93-94 after selection of Subdivision Advisory Board as per advertisement dated 3/9/1991. After selection, they were appointed in different middle schools under the Bongaigaon district. Accordingly, they were receiving monthly salary up to May 1995. Thereafter, the retention of those posts were not received from the government as their posts were reflected in the list of Manoharan Committee illegal. Their salaries were stopped after that. And subsequently, in
So from
pursuance,
what are you reading?
Lordship, the affidavit filed by the Lordship Suranjana Senapati, director, on
Which paragraph? Respondent number 2.
yes, respond paragraph 6.
This is in your favor.
This particular paragraph is in my favor, Lordship.
After selection, this is the what
After
you
selection,
said.
yes, Lordship. This is an admitted position, Lordship. And they have also given the advertisement date as 3/9/1991.
See, but the things what I was just pointed out was that in 2006,
Lordship.
you were regularized.
Lordship. And Lordship,
And you submitted your undertaking without any saying anything.
Lordship, I have given a reply to that, Lordship. In my affidavit in reply, Lordship.
You
the
tell
affidavit-
me, you
Yes.
tell me,
Yes.
where's that regularization? Page 53.
Yes.
This order is of 2006.
Yes.
When your regularization came, you applied, you also gave undertaking and you played along. But suddenly in
Lordship, that was-
2022,
Yes.
please let me complete.
Yes.
2022, you thought it fit that I should complain now. Otherwise, I will be suffering. Why?
Lordship, most of the Lordship cases, Lordship, were filed during that period, Lordship. This NPS and OPS.
Back end of your service, you realize that my old pension is more beneficial. You have been contributing every time since 2006 till 2022. So you're very
Lordship, one more judgment I have given in my reply also, in my affidavit in reply. And
What-
under what circumstances we have to give the compelling Lordship, that in that regard also there are judgments, Lordship.
that circumstances cannot be wait for how many years? How many years you have waited?
In 2006, Lordship, because we did not have any bargaining power, Lordship, against the mighty
And
respondents.
In 2022, you
In
started
two-
having
in-
bargaining power.
No, in 2006,
2006, you did not have
yes,
because at that time you have to immediately.
yes, Lordship.
After getting that benefit or
Yes.
getting the regularizer benefit, you should have questioned.
Lordship.
I'm going the benefit, but now you see there's something wrong with this regularization. My pension should be from all pension, not this, because I've been appointed 93-94. You could have said that in 2007, 8, 9, 10.
That particular scheme came
But not
into,
in 2022.
that scheme came in 2009, and they said that they will frame a rule, and pension rule was framed in 2023. That particular amendment, Lordship.
Then what happened in between then?
That is exactly, Lordship.
Those who retired, what will they get
Lordship.
without rules?
That is exactly why I was, Lordship, referring to this judgment, Lordship. Exactly same point has been decided, Lordship.
Which judgment?
Review petition 16 of 2019 and 8694 of 2018.
This newspapers.
Yes, Lordship, paragraph 6. 8694, paragraph 6, Lordship.
Review petition filed by whom? Review of which order? you please come to paragraph 6.
Yes.
This is the situation.
This is the situation.
The new defined contributory scheme
Yes,
came into effect with the amendment of 2011,
Lordship.
by notification dated 14/7/2011, with retrospective effect from 1/2/2005. But review was dismissed. Who had filed this review?
Review was filed by the state.
Oh, by the state.
Lordship. I am relying on paragraph 9 of the review.
Please read.
Lordship. In the present case, the petitioner services having been regularized on 4/6/2008, the petitioners became regular government servants on 4/6/2008, and as the 1969 rules was in force at the relevant point of time, the executive instruction issued could not have overridden the statutory law. As such, this court had accordingly directed that the petitioners would be governed by the 1969 rules and not by the new defined contributory pension scheme, which came into force only by way of amendment of the 1969 rules in the year 2011. Sorry. In the case of Dilip Kumar Ghosh versus Chairman reported in 2005, 7 SCC 567, the Apex Court has held that the circulars, notification, administrative, executive instructions, orders, etc. cannot override the statutory rules. The grounds of review in ground D and E of the review petition are reproduced below. For that, since the Assam Service Pension Rules 1969 got amended in the year 2011 with effect from 1/2/2005, on the date of passing of the judgment and order dated 1/9/2003, the earlier provisions of the Rules 1969 existed, but the same is not in force with effect from 1/2/2005 for the teachers whose services were regularized on or after 1/2/2005. On the date of regularization of services of the petitioners, the Assam Services Pension Rules 1969 had already been amended by introduction of new pension rules by government order dated 25/1/2005. Therefore, the review petitioners are also praying for clarification of the direction contained in paragraph 6(6) of the order dated so and so. For that, the Assam Service Pension Rules 1969 was applicable to the drop teachers at the time of passing of original judgment and order dated 1/9/2023, but due to subsequent sense amendment of statutory provision of pension rules, that is the Assam Service Pension Amendment Rules 2011, with effect from 1/2/2005, the other government notification order issued from time to time, the review petitioners are facing difficulty to count their past services for pension as it was done prior to 1/2/2005. The petitioners are entitled to the pensionary benefits as per the existing rules in force, which was applicable at the time of their regularization. In the instant case, on the date of new defined contributory pension scheme was in force, and the Assam Service 59 was amended with effect from 1/2/2005. As a perusal of the above clearly shows, the prayer of the review petitioner is not due to some mistake or error apparent on the face of the record. Further, the prayer for clarification of the direction of 6C of the judgment and order dated 1/9/2003, passed in CR number so and so, cannot be acceded to. And as this is not a review case against the said direction passed in CR, in view of the reasons stated above, this court is of the view that no case for review has been made out. Accordingly, the review petition stands dismissed. So the review filed by the state was dismissed, and Lordship, in terms of this order, Lordship, subsequently, Lordship, this honorable court has passed order, Lordship. Just one paragraph, Lordship. Paragraph 6.
Where?
I have given Lordship, WPC 8694 of 2018.
So we'll come back at 2.
Lordship.
Okay. Break time. No. There you are.
Lordship, before the break, Lordship has seen the review order, Lordship. Now, Lordship may kindly come to the other judgment, Lordship, 8694 2018. I am relying upon paragraph 6. May I read, Lordship?
Yes, please read.
As indicated above, the issue involved has already been decided by this court by the judgment dated 28/4/2015, passed in WPC 3622 of 2009. it has been held that the NPS would not be applicable to the petitioners whose services were regularized prior to the amendment of the 1969 rules. It may be mentioned that the judgment order dated 28/4/2015 passed in the aforesaid writ petition was the subject matter of review in review petition number 16 of 2019. And this court had an order dated 11/2/2021 had dismissed the prayer for review in the following manner.
Okay, this, where is this order?
Review order, Lordship,
Not,
has-
not review. WPC 3662, 28/4/2015, where it was already decided. The review basically was dismissal only.
Yes.
That there's nothing to review.
Yes.
But where is this order?
3662.
3662?
Lordship, that judgment is not available right now, Lordship.
Can you just find out? WPC 3662 of 2009.
Nine.
Order dated 28/4/2015. The printer cartridge has to be changed. Quite faded. Is it because of the printer? This is good. Must have read this judgment. Have you read it?
No.
You've not read it?
Maybe Lordship, but today it is not available.
Huh? Give him this copy. I think he's got a better eyesight than me. He can read.
Yes, I have read, Lordship, I have read this. earlier.
Which paragraph helps you? There's some reference about one civil rule, civil rule number 15771.
Yes.
One nine 2003. What is this judgment? This is in civil rule.
Lordship.
Again, relates to civil rule.
Yes,
1571 of 1998.
98,
This was a judgment dated 1/9/2000.
2003,
It says that it has attained finality
Lordship.
and it has been direct. All appointments made would be prospective, but will carry the benefit of past services
Lordship.
for computation of pensionary benefits. I find the petitioner's service may be counted for the Assam pension rules 969.
Lordship.
Past service be counted for the purpose of computation. So this relates to that this civil rule.
1998. Lordship.
Then review was sought
Lordship.
on the ground that that amendment came,
Lordship.
isn't it?
Lordship.
Amendment came, so amendment has been made effective with a retrospective effect.
Retrospective.
So
That cannot be,
that
because that notification and guidelines cannot override the statutory provision. That is held by the court. Lordship. Circulars, notification and administrative executive instructions.
cannot override which provision?
The amended provision of the 1969 rules that has been brought in 2011. We have challenged the OM Lordship 2009. They said that we are contemplating to bring the amended rules in the future. And in 2011 Lordship, they have brought this amendment Lordship. I have the copy.
Amendment is made by way of what?
By
Executive
way of,
instruction.
by way of a notification Lordship.
Executive instruction,
Lordship.
not 309.
Not 309.
Okay.
Lordship, I have that amendment Lordship. That is on 14/7/2011.
Okay. No, this is 309. In persons of the approval of the cabinet and exercise the powers under proviso to 309.
But it cannot have retrospective effect also.
No, that is another thing, retrospective, about regarding the overriding of statutory rules by
What?
executive instruction. That is not there.
Lordship, the annexure 5, page 105, that notification was by an office memorandum 6/10/2009. That notification cannot.
Where's that?
In my writ petition, annexure 5, page 105.
This is the introduction of the
Lordship.
NPS.
Lordship.
Is this how the new pension scheme was introduced?
Lordship.
By way of OM?
OM. That is why Lordship, the judgment which I have referred, those petitioners, their services were regularized in the year 2008. The Honorable Court has held that this notification and other circulars cannot override that because that 69 pension rules was prevailing at the time, at the point of time, Lordship. In my case also, Lordship, our services were regularized in the year 2006. So to 1969 pension was holding the field. So this office memorandum cannot override that statutory provision.
Okay, that is your case.
That is
Anything
the-
else?
And several cases have been disposed of by this honorable court lordship following the said judgment. Even your lordship has also passed few judgments lordship.
Where is that?
The lordship, one case I had.
This was for verification.
Yes, lordship. And lordship, there is one more development, lordship. I just bring to your lordship notice. In 19/7/2025, the government has taken a decision that those the process which has started prior to 1st February 2005 have been collected in the prescribed format provided by the finance department from the district education officer. As of now, the data employees, our names are also there, lordship, in this list. Now they have taken a decision, lordship. There is also a minus in the meeting with the.
What is the purpose of this?
To lordship, now they have given, they will give old pension to those where the recruitment process started prior to 1/2/2005. Also, our appointments were way back in 1993, 1994.
No.
So they have all,
Okay, where does it say here that they will give all pension? Submission of detailed information, those who join after February 2005.
Loss.
But whose recruitment process was started
Loss.
prior to 2005? Where is your name?
Lordship, this is the minus. Lordship.
Where is your name? You're giving one after the
Loss.
other documents.
Lordship, our name is Lordship, that annexer, Lordship.
Annexure where? Serial number?
Serial number 18, serial number 17, 20, 21, 22, 23, 25, 26.
17,
And
18?
lordship, serial number 3 also.
Serial number 17, 18 and 19.
Serial number 3, first page. Then lordship, serial number 17, 18, 20, 21, 22, 23, 25 and 26.
How many total? 9?
9. Others, lordship, I do not have lots. I have only got this copy.
There are 15 petitioners.
15 petitions.
So now why are they collecting this data?
To process the lordship, to process the lordship payment of old pension. That is the minus. That is the reason of the minus of the meeting held along the.
So your writ petition is infructuous then?
No, that is only a process, lordship. Even the division bench also, lordship, they have given this statement, lordship, that there is a process going on. We are considering, but they have
Division
not
bench?
considered before a division bench.
What matters there in division bench?
One division bench matter was there because another set of writ petitions were dismissed by this honorable court. They went before a division bench. Then division bench passed an order saying that since there is a process, may I place the division bench order?
He's already here.
Yes, yes.
Case number?
Writ appeal 188 of 2000.
It is here.
Yes, yes.
In view of the above development, we are of the view that the state government decide to consider the demand of so and so.
Yes.
Writ appeal is disposed awaiting the results. It is made clear that the applicants fail to get favorable decision from the state, they are free to approach this court again.
Yes.
That much only.
Now they are collecting the document data. We belong from the Bongaigaon district, Lordship. Lordship, my case is squarely covered by the decision 12/8/2021, passed in WPC 8694 of 2018, Lordship. I am relying upon that particular paragraph, Lordship. Exactly same situation, even Lordship, we are in a better footing, Lordship, because their services were regularized in 2008, our services were regularized in 2006.
That's all? That's all?
Lordship.
Yes.
One more thing, Lordship. With regard to the allegation of Lordship, excess appointment and giving undertaking, I have given a detailed reply in my affidavit in reply, Lordship.
Saying what?
Because we do not have bargaining power at that point of time, we have to, under compelling situation, we have given that undertaking, and I have also quoted one judgment of the Supreme Court, Lordship. Lordship may kindly come to my affidavit in reply once, Lordship.
Okay, that you leave that.
Yes.
Let me hear Mr. Borgo.
Yes.
Mr. Borgo.
I am representing the finance department.
Yes.
Because this is basically a case where, my lord, it is not that the petitioners will be deprived of any pension, or that for that matter, some of the petitioners have retired, as I have heard from him. Now, pension is available to them, but in what category? Whether they will be governed by, they will be entitled to the benefits under the 1969 pension rules, that is normally which we call in the common parlance as OPS, or they will be governed by the new pension rules, my lord.
Exactly.
So this is precisely the issue. Now, lord.
Now, you have appeared in this case also. WPC number 8694 of 2018.
Yes, there, my lord, the fact circumstances are different. I will distinguish.
No, different in the sense that they were regularized from the year 2009, correct?
2008.
2008.
That's
Out here, they are regularized with effect from
2006.
So that is the difference only.
So that is the difference, and further, my lord, there are subsequent decisions, my lord, passed by this honorable court, which have now attained the finality, and the law has been set by this honorable court, my lord, with regard to the various categories of teachers who will be entitled to get pension under the old pension rules or the new pension. I will come to that, my lord. Prior to that, my lord, basically, if lordship may be pleased to come to page 17 of the writ petition, my lord. That is the prayer portion. They are seeking a mandamus. They are seeking a mandamus, my lord. The first prayer is, my lord, writ of certiorari shall not be issued to set aside and quash the impugned OM dated so and so. In the earlier round of hearing, my lord, my learned colleague, my lord, had made a statement before this court, my lord, that he will not be pressing prayer number 1 and 2. I believe, my lord, he sticks to that. Prayer number 1 and 2. Because I will be advancing my arguments subject to what he, my lord, says, my lord. He says, my lord, that prayer number 1 and 2, my lord, he is not pressing. He is only concerned with, my lord, prayer number 3.
So you want an undertaking from him before you advance your argument?
I don't remember, Lord.
Anyway, then, now, my lord, so far as prayer number 3, because prayer number 3 will be a fallout of prayer number 1 and 2. Prayer number 3, lordship will kindly see, a writ of nature mandamus shall not be issued to consider the case of the present petitioners under the old Assam Service Pension Rules, which was in force so and after hearing the parties and perusal of records, make the rule absolute. So they are praying a, my lord, writ of mandamus, which would be a positive direction. Even if I concede that, even if at the end of the day, lordship, my lord, decides that this writ petition and quest the memorandum, and my lord, the impugned condition of regularization, my lord, then, my lord, the prayer number 3 will be independent prayer. So my first contention here is that, my lord, this writ petition is fundamentally defective because of the fact they have not demanded justice prior to filing of this writ petition. And for issuance of a writ of mandamus, my lord, in my most humble and respectful submission, my lord, before this honorable court, the petitioners ought to have made a demand before the authorities. Only when the authorities, my lord, deny them justice, then only, my lord, they will be entitled to move this honorable court by filing a writ petition under Article 226. There is not a single document or any averment made in the writ petition, my lord, that the petitioners have preferred any representation before the authorities. Because lordship has rightly pointed out, they were regularized way back in the year 2006. They have accepted their appointment orders with their eyes wide open. And they could have preferred a representation, my lord. In fact, at least one of the petitioners could have preferred a representation before the authorities. That look, my services have been regularized.
There's
now,
one word for that.
my lord,
There's one word or two words. Fence sitters.
fence sitters.
They are fence sitters.
Absolutely.
That's what you say.
Absolutely. Fence sitters, and nonetheless, Apex Court is very much clear. I will be producing the judgment, my lord. I do not want to burden this honorable court.
What is the judgment?
My lord, one has to make a demand before seeking a writ of mandamus. That is a settled position of law. Lordship may be pleased to see, my lord, paragraph 9. My lord, paragraph 10, my
Mr.
lord.
Board Pujari,
My lord.
you are arguing on the technicalities. You are on the technicalities. Why don't we go for the larger picture?
No, larger picture, I will go. But why I am making this
You
submission,
are
man?
going there technically, this is not there, that is not there, this is not there.
No, my lord, this
See,
is,
the purpose of the interest of justice would demand that some substantial justice is done.
no, so
So
there,
broadly speaking, a person who was appointed in 93, 94, regularized in 2006,
my lord.
and had been somehow asked to give an undertaking that you should come under this, and who has no bargaining power, have been drifted to that area,
Yes,
and the rules also not having been finalized, pension rules coming only in 2011, and saying that this will apply from 2006 or 2005, 6.
2005,
Fine.
1st of February 2005. That is the
So
cutoff
whether
date.
that would be a fair situation,
Yes,
there are judgments here already referred to.
no, there are counter judgments also. I will be placing, but first of all, lordship will.
Counter judgments like what?
My lord,
That they are not entitled.
yes, they are not entitled. They fall within.
Why?
The
Why?
Because admittedly, they fall within the category of excess teachers. There are various categories of teachers in the education department. Lordship has been dealing with this matter. There-
Excess teacher.
Yes, excess teachers. There is a category called excess teachers. There is a category called stipendiary teacher. There is a category called my lord, drop teachers. There is a category which called my lord, 6 scheduled teachers. All
No.
these my lord teachers.
What is the thing that distinguishes them? If they are excess teachers, then you don't drop them.
No,
Why did you regularize them?
regularize them because on inquiry, they were found, my lord, that there was an inquiry. There
No,
was
you
a-
cannot apply two yardsticks. Teachers appointed, out of 50 teachers, 10 of them are excess. So for 40, we'll apply this pension. For 10, we'll apply the new one. Can you do that?
No, my lord, the excess teachers who have been regularized because the situation was such, my lord, that advertisements were made way back in the year 1991. Thereafter, they came to be appointed in the year 1994. Lordship has seen it. It is a part of the writ petition. Now, my lord, 1994, they were appointed. Then, my lord, the appointments were made in excess of the sanction post. So there were disputes. There were several disputes. And, my lord, the state of Assam in the education department appointed an one-man inquiry committee called the Manoharan Committee. And that one-man inquiry committee made my lord, an inquiry and found, my lord, that those excess teachers, my lord, those who were appointed in excess of the sanctioned vacant post, my lord, have to be given a go-by. And those who come within the sanctioned vacant post, my lord, within the limit, permissible limit, they can be regularized. Accordingly, this regularization order, which appears at page 53 of the writ petition, lordship has seen it, my lord.
Yes.
It categorically says, my lord, that they were appointed in excess of post. They were appointed in excess of post. But nonetheless, the government has taken a magnanimous view of the matter and have sought to regularize their service and retain them in service. Now the issue falls that whether their past service prior to regularization can be counted for the purpose of giving them the benefit under the 1969 pension rules.
That is for the excess appointed teachers.
Yes, now this.
What about those who are appointed as per the sanctioned posts? They are given what?
They
What?
are, they are given, my lord, the old pension. rules.
All pension.
All pension.
See, that is why,
Yes,
that is what exactly I was indicating.
absolutely.
How can you apply two different things for similarly situated persons?
But this is the law.
By merely terming that they are excessively appointed.
Yes. They are in excess appointment, my lord. So therefore, they are not entitled to, my lord, the old pension scheme. And to that extent, my lord, this honorable court, because a large number of teachers in the education department, my lord, moved this honorable court by filing several writ petitions, almost more than 100 of writ petitions. All those writ petitions were clubbed together, and all those writ petitions were disposed of by a common judgment and order by this honorable court in the case of Purnima Hore. That is, my lord, I have made a statement. in
Case
my-
number?
That is, my lord.
Civil rule.
Of 2021. It's a long judgment, my lord. But I have mailed it, my lord.
6403.
Well, it should not be there, my lord. It's a voluminous decision. I have
What, anyway, what is the sum and substance of the judgment?
Yes. Now, there, my lord, various categories of teachers came before this honorable court, and finally, this honorable court, my lord, was pleased to dispose of those batch of writ petitions. Now, this decision has attained finality, and against this decision, my lord, against this decision, some of the aggrieved persons, my lord, the petitioners, who failed in their writ petitions have moved the honorable division bench, which lordship has just now seen.
No. What was the decision of the learned single
Yes,
judge?
my lord, that I am spelling it out, my lord, at paragraph 118.
What does it say?
It says, my lord, in the backdrop of the above, this court therefore disposes of the instant batch of writ petitions with the following observations and directions. Number one, the writ petitioners who come within the fold of stipendiary teachers are entitled to the benefits under the rules of 1969, and they are not covered under the new defined contributory pension scheme 2009. That is for stipendiary teachers. The said petitioners are also entitled to subscribe to the GPF. The said petitioners would also be entitled to all other pensionary benefits corresponding rank is entitled to. Then number two, the writ petitioners who come within the fold of drop teachers are not entitled to pension in terms of the rules of 1969, as well as also shall not be entitled to join the fund in terms of the General Provident Fund Assam Service Rules 1937. But they shall be governed by the new pension scheme applicable to the state government employees of the corresponding rank.
Now, what is the beginning of the sentence?
My lord?
Just now, you read?
Yes, the writ petitioners who come within the fold of drop teachers are not entitled to pension in terms
Okay.
of the rules of 19. So
Drop teachers.
Drop teachers.
This is a case of excess teachers.
Excess. It is also there. I'm coming, my lord. Then, my lord, the teachers coming within the fold of appointed under the Operation Blackboard, which we normally say OBB teachers, my lord, are more particularly those teachers who were appointed pursuant to creation of 7,066 posts in the year on 8/3/2021 would not be entitled to pension in the terms of rules of 1969. Then, my lord, excess teachers. The writ petitioners who come within the fold of excess teachers would not be entitled to the pension in terms of rules of 1969, as well as also shall not be entitled to subscribe to the fund in terms of the General Provident Fund Assam Service Rules 1937, but they shall be governed by the new pension scheme applicable to the state government employees of the corresponding rank. So there is a clear and categorical finding by this honorable court.
What is the judgment date?
My lord, that is judgment and order dated 31/3/2023. 31/03/2023. My lord. Passed in WPC number 6403 of 2021. The lead case is, my lord, Purnima Hore. Purnima Hore, HORE, my lord. Well, I have mailed the soft copy, my lord.
Purnima Hore versus state.
State of Assam, and other analogous writ petitions. Almost, my lord, hundreds of writ petitions were disposed of by this common judgment and order.
Now this has been put to challenge.
This has been put to challenge,
And-
and the honorable division bench have till now, my lord, not interfered with this one. And this is the law.
Not interfered with because the division bench was informed.
Yes.
It is further submitted that the issue regarding extending the benefit of old pension scheme to those employees who join government service after 2005, wherein the recruitment process started to is pending with the administrative department. In view of above, so and so and so.
Yes. So therefore, what had happened, my lord, I will clear it, my lord.
So again, we are back to square one.
Yes. So therefore, my
So
lord,
question is, do we wait or do we decide?
my lord, in my respectful submission, my lord, they can lay a claim before the authorities. Let them file a representation before the authorities. And now, and now, my lord, there is a move, although it has not attained finality, there is a move by the government, my lord. Maybe, my lord, the new pension scheme may be replaced again by the old pension. Now, one UPS.
You also admit the fact that some things going on, isn't it?
Yes, yes, it is going on.
Submission of detailed information and there's some list is here.
Yes, yes.
Few names have been given.
Yes. All,
Why all this list is collected? This is all because
my lord,
to find out whether these people will be covered by the new or old.
particularly the financial implications involved. Because under the new pension scheme, if I am getting rupees 100, under the old pension scheme, he may get rupees 105 or 110 at the end of the day.
So if the parties agree, we'll dispose it of in that manner
Absolutely.
without prejudice.
That is why.
Since that process is going on,
Absolutely.
let all the materials be collected and let them consider your case. And you may also give some demand if you want to.
No, therefore, my lord, they can lay a representation before the authorities. And since now, my lord, much water has also flowed, and my lord, the issues have taken a new dimension, my lord, to the effect that, my lord, at the end of the day, they may be benefited with the OPS scheme again being revived for all persons concerned over the board, my lord. But they can lay a claim. Therefore, at the very initial stage of my argument, I have relied on the Supreme Court decision that they have not demanded justice. Let them file a representation. Let
See,
the authorities decide.
Problem is that some of them are retired since. So what will happen to them?
No difficulty. Lordship will kindly appreciate. They are not denied of pension. They are getting pension. Only, my lord, the quantum is at dispute, my lord. Only the quantum. It is not that they are totally deprived of any pension. They are getting pension.
That is there. I understand, you see.
Absolutely.
For those of us who are not affected personally by this kind of pension thing, we say, okay.
Yes.
But for those who are, like depending on this,
Even-
it's a different picture altogether.
Absolutely.
That is why.
Absolutely.
You have to feel their pulse also.
No. Lordship is correct. Lordship is absolutely
Lordship,
correct.
may I give a short reply, Lordship? My hotmail friend.
But do you agree to that proposition? We dispose it off.
Lordship, disposing what, but
I'll not foreclose your right
Yes,
to
yes.
challenge whatever.
Lordship, what my learned friend has stated, that my case is covered by Purnima Hore. In fact, Lordship, this writ petition was also along with the analogous writ petitions before the author of that same judgment, Honorable Justice Debashish Borua. Lordship, after going through the records, Lordship, after going that there is a proper advertisement, there is a selection, the Honorable Court, Lordship, on by itself has segregated my case from that group of cases.
I'm not
My
aware.
Lordship will, my friend will admit that.
I am not
He
aware.
was he was there. My case was segregated from that among the group because there is an advertisement, there is a selection process, and lots we are appointed against sanction and allotted posts created by the government. After looking at those things, Lordship, my case has been segregated from that analogous
Mr. Porbojari would like to say that you have been appointed against, you belong to that category where there's excess appointment.
Excess appointment, I have given reply in page 151. Lordship, excess appointments where there are 209 number of tutors. Lordship, 151 of my affidavit reply. May kindly see. Excess teachers are called as tutors and there are total 209 numbers of tutors in Bongaigaon district and the tutors are receiving gross salaries. Page 151 Lordship. 200 numbers of tutors in Bongao district. The tutors are receiving gross salaries at the rate of 10,800 and net salaries at the rate of 10,600. But the petitioners are receiving gross salaries at the rate of 57,540 and net salaries at the rate of 51,742. And Lordship, we are appointed against sanction and post creation number is also there. Lordship, may kindly see my appointment letters. And it is an admitted fact also in their affidavit also we are selected by the sub-divisional level selection board pursuant to the advertisement. So we are not any illegal or irregularly appointed teachers.
Anyway, we'll make an observation to that effect and dispose it of.
Yes.
Please write down, heard Mr.
SK Das, Lordship.
SK Das, Learned Counsel for the petitioner, and Mr. R. Borg Pujari, Learned SC Finance. Mr. Who else is there? Hmm. Mr. PK Bora, SC Elementary. And this K. Fukan. Response number 3. Mr. Bora is for response number 1 and 2.
I am for R4, my lord.
And Paul Pujari for R4. Next para. How many petitioners? 15. 15 petitioners are before this court. By way of this single repetition, with the contention that they have common grievances and one and the same cause of action. Stop. The petitioners were all appointed as assistant teachers in Middle English, in either Middle English or Middle Vernacular schools. Pursuant to the advertisement floated by the respondent authorities on 3/9/1991. The process of selection culminated into their appointments on different dates in the year 1993 and 94, correct?
Yes.
Stop. It is the case of the petitioners that they were appointed in the scale of pay and against sanction post. And after due selection process, stop. Their services were regularized with order dated 31/2006 with effect from the date of joining their service. Stop. The regularization process was preceded by an inquiry made by one-man inquiry committee headed by Sri S. Monoharan, IAS. Since there was an allegation of anomalies and anomalies in making excess appointment, over and above the sanction posts. Stop. It is, however, the case of the petitioners that they have not been, they do not belong to the category of excess appointees. And in fact, they have been appointed against the existing posts with the appropriate pay scale. Next para. The learned counsel for the petitioner submits that at the time of regularizing the services of the petitioner, they were required to make an undertaking that upon joining government services on or after 1/2/2005, comma, they will not be covered by the Assam Service bracket pension close bracket rules, 1969. But by the new pension rules being formulated in line with the contributory pension scheme of the Government of India, to be notified in due course. Stop. The learned counsel submits that the petitioners were not in a and they had to give in making such an undertaking. Stop. He, however, submits that since the petitioners were appointed after due process against sanctioned posts way back in the year 1993 and 1994, they should be governed by the old pension rules of 1969, which was occupying the field on the date of their regularization. Stop. The learned counsel draws support of the decisions rendered in similar other writ petitions. Being WPC number 8694 of 2018, disposed of by order dated 12/8/2021, open bracket, Sukumar Sarkar and 7 others versus State of Assam and others. And WPC number 3662 of 2009. disposed of when was it disposed? White judgment or an order dated 1/9/2003. No, sorry. White order dated 28/4/2015. Open bracket, Dilip Kumar Mehdi and 28 others versus State of Assam and others. Close bracket. Amongst others. Stop. The learned counsel submits that the case of the petitioners is squarely covered by the earlier decisions and therefore similar benefit may be granted to them. Stop. He also submits that during the pendency of the writ petition, petition numbers 1, 3, 5, 9, and 10 have since retired. Stop. The learned counsel further submits that the state respondents in the elementary education department themselves are aware of the fact that the petitioners are also entitled to be covered by the old pension scheme. And therefore, they are in the process of collecting detailed information of the employees who joined government service on or after 1/2/2005, but who were recruited, but whose recruitment process had started prior to 1/2/2005. He therefore submits that appropriate direction may be issued to the respondents to extend the benefit of old pension scheme to the petitioners. Next para, Mr. R. Borbuchari, Learned Standing Counsel, Finance Department, on the other hand, submits that a number of employees claiming to enjoy the old pension scheme had approached this court by filing their respective writ petitions. And this court had disposed of the writ petitions by way of a common judgment in order dated
31/3/2023.
31/3/2023.
In the
And the lead case being WPC number 6403 of 2021.
my lord,
Open bracket, Purnima Hore and another versus State of Assam and others. Close bracket.
if lordship may be pleased enough, my lord, I'm sorry, my lord, I'm having a soft, my lord,
It's okay.
I'm
You have given me a copy.
I'm obliged. I'm obliged.
The Mr. R. Bor Pujari submits that this court had held that persons who were appointed in excess of the sanction post would not be entitled to be covered by the old pension scheme. And instead would be governed by the new pension scheme. Stop. He submits that agreed with the decision of the court. The petitioners have approached the division bench of this court by filing writ appeal number 188 of 2023. Stop. The writ appeal was disposed of on 26/7/2024 after the division bench was informed that the state respondents were in the process of collecting data, public particulars of the employees who had joined after the year 2005, but whose recruitment process started prior to 2005. Stop. The division bench observed that in view of such development, the writ appeal should be closed. With liberty to the appellants to approach again in case the decision of the state government was not in their favor. Stop. He therefore submits that the instant petitioners have directly come to this court without approaching the respondent authorities, and therefore the petitioner should be relegated to approaching the respondent authorities with appropriate application. For making a claim to enjoy the old pension scheme. Next para, Mr. So-and-so, learned counsel for the petitioner, in response submits that the petitioners do not belong to the category of excess teachers which can be seen from the amount of salaries received by them. Stop. He submits that the excess teachers are called as tutors and are 209 in numbers in the Bongaigaon district and receiving gross salary at the rate of rupees 10,800 and net salary at the rate of rupees 10,611. Stop. The petitioners, on the other hand, are receiving gross salaries of rupees 57,540 and net salaries at the rate of rupees 51,742. Stop. Therefore, they are only entitled to be included amongst those teachers appointed during the subsistence of the old pension scheme and accordingly given such benefit. Next para, I have considered the submissions made by the learned counsels for the rival parties. And I have perused the materials available on record. Stop. One aspect of the matter which has been brought to the notice of this court is in respect of the steps taken by the Elementary Education Department in collecting detailed informations from the employees who joined services on or after 1/2/2005, but whose recruitment process were started prior to 1/2/2005, would go to indicate that an attempt has been made to identify such employees so that it can be determined as to which of the employees would be covered by the old pension scheme and who would be covered by the new pension scheme. To stop, the learned counsel for the petitioner has produced a communication dated 19/7/2025 issued by the Director of Elementary Education in respect of such kind of information, wherein name of some of the petitioners find place at serial number 3, 17, 18, 20 to 23, 25 and 26. Stop. Therefore, in view of such process being undertaken, petitioners to their service particulars and details before the Director of Elementary Education with a prayer for grant of the benefits under the old pension scheme within a period of
1 month. Or 2 weeks looks.
2 weeks is sufficient.
Okay.
15 days from today. Stop the director upon receipt of such information shall consider the same and take necessary steps as may be required for ascertaining whether the petitioners are covered, petitioner will be covered by the old pension scheme. Such decision should be taken. How soon? Within a period of 3 months from the date of receipt of the representation, along with a certified copy of this order. Next, para the above decision and direction. No, the above direction is given without any prejudice to the right of the petitioners to what? Not required, no. Anything else to be added?
Kindly Lordship incorporate paragraph 6 of the stand taken by the Director of Elementary Education, Lordship. That particular paragraph.
Where is that?
Paragraph, page 113, Lordship. Paragraph 6. The petitioners were appointed during 93-94 after selection of Subdivisional Advisory Board.
In taking a decision, the Director of Elementary Education shall also take into account the stand taken in paragraph number 6 of the counter affidavit filed by the said authority on 21/7/2023. Admitting that the petitioners were appointed after following due process of law in terms of the advertisement concerned. With the above observation and direction, read petitions as disposed of.
Lordship, one more thing, Lordship, as per law of equity, Lordship, we are praying for similarity of treatment. If that can be, similarity of treatment in terms of WBC.
You incorporate that in your thing.
Lordship.
I'll put this in record.
Lordship.
One more line.
Lordship.
A copy of the communication dated 19/7/2025 produced by the learned counsel for the petitioner shall be retained on record and marked as X for identification. Communication dated 19/7/2025 of the Director, Elementary Education, to the Secretary to the Government of Assam School Education Department.
Obliged.
I'm so obliged, man.
Or mentioned. Okay.
May I please, Your Lord?
Yes.
Lordship, this matter pertains to the student union's election Basically, before I start, Lordship, the student union election is basically governed by the judgment of the Honorable Apex Court in University of Kerala versus Council of Principal, in which the recommendation of JM Lindo Committee was adopted and the guidelines were framed accordingly. So a set of the judgment I would like to just. So following the judgment, the respondent number 5 have issued notification, and the rules were framed, rules for election of student union for 2025-26 in respondent number 3 college, so which is at page number 29, annexure 1.
Page number
29. Annexure 1 is the type copy.
Yes.
In this rules, rules number 2, the candidate must have 75% of attendance, and the rule number 5, that is the candidate shall not have any previous criminal record. He or she should not have been subject to any disciplinary action by the college authority. These are the 2 important rules which I will be placing.
Number 2 and
5. Number 2 and 5.
Okay.
Thereafter, Lordship, along with this notification, the minutes of the election was issued, which is annexure number 2, page number 35. In this, Lordship, on 10th, on 10/10/25, the scrutiny and declaration of valid nomination was supposed to be done. And on 14 and 15, stage campaigning was supposed to be done. Thereafter, a notice was issued by the principal stating that due to unavoidable circumstances that scrutiny and declaration of valid nomination could not be done. So it was postponed to 13th. Which is at page number 36, annexure 3. The petitioner has filed their nominations, and on 13th, the list 7, annexure number 4. The name of petitioner, that is for the post of petitioner number 1, for the post of president, that was rejected on the ground that below attendance norms.
This is petition number 1.
Petition number 1, that is number 3 for the post of president, Shariful Islam. And the petitioner number 2 for the post of that is Shahid Anwar. Petitioner number 2, his nomination was also rejected on the similar ground, that is below attendance norms. Thereafter, the petitioners have submitted representations, and more than, including the petition number 1 and 2, more than 100 students have submitted a representation, a joint representation to the election commissioner on 13th itself, 13/10, which is at page number 38 is the type copy, and the original is at page number 40. In this, they have stated, the students have clearly stated that the guidelines and the rule number 5 was clearly not followed. Thereafter, the recommendation of the guidelines as per the Lindo committee, that is 0.655, was also not followed. And since their names was rejected on the ground that their attendance was below, so they have requested to provide the details to them, because as per petition number 1 and 2, their last year attendance was above 75%. Their this year attendance is also above 75%. But the annexure number 5 and annexure number 6 were duly received by the authorities, but till date no reply. Thereafter, on page number 49, a notice was issued by the authorities. The respondent number 5 issued
the notice, that is annexure number 7, whereof they have stated that fresh on 14/10/25, Lordship. This is and 14/10, that since some of the portfolios have been rejected, so fresh nomination were called for. Yeah, because of my representation, this was done. Now, thereafter, on the same date.
Just a minute.
Yes.
This annexure 7, what is it?
Annexure
about?
7. May I read, Lordship?
Yes, read.
Yes. Notice, it is for general information to all the student of FA College, Goimari, that all the nomination in the undersigned mentioned portfolio has been rejected by the Election Commission of Election of Student Union, so and so, FA College, Goimari, for less attendance, less than 75%, and age bar issues. Hence, the Election Commission has decided to reschedule the election minutes by giving another chance to the intended and eligible candidates to nominate.
So this is due to the rejection of this.
Yes.
1 and 2.
Thereafter, annexure 8, the new timeline was again drawn. In this, they have done everything on 15th, and the submission of nomination paper, declaration, issuance and withdrawal, declaration of valid form, all was done on 15th. Yes, that is yesterday. Today, only one date was left for campaigning. Thereafter.
Okay, just a minute. One thing. President and Vice President post.
Yes, Lord.
By which the petition number 1 and 2 had nominated themselves.
Yes, Lordship.
That was not accepted.
Not accepted. They.
So that was being not accepted. Again, they opened nomination.
Nomination they have accepted, but for these two posts, it was not open.
Sorry?
For President and Vice President, it was not open.
It was not open.
Yes, it was not open.
Open for what then?
So for other posts, General Secretary, Assistant General Secretary, Games, Sports, Social Service, Culture and Religion, Debate Seminar.
But in that General Secretary, there's none of them. That's why.
Yes.
I see.
So
it's only the nomination of President for 1 and 2.
Yes.
I mean, in the column 1 and 2, then in the Vice President only 1. Only 2 persons were found to be eligible.
Yes.
In Vice President, only 1.
Only 1.
But nomination is not open.
Well, nominations were open.
Not open.
Not open for him.
Okay, serial number 1, 2, 3. Okay, General Secretary, Assistant.
Yes.
Okay.
So thereafter, a reschedule minutes were notified, and in this reschedule, everything was done yesterday itself, 15th. No opportunity was given. Thereafter, and moreover, they have not even disposed the representation submitted to the respondent number 5 till date. The 16 was, there were 2 dates given for staging campaign. That was also reduced to 1 date, and tomorrow the election has been declared. They're polling. So, on 15th, that is yesterday, a notice was issued. That is at page number 51, annexure number 9.
What is this?
This was the notification that candidates who are found valid after withdrawal of the nomination for ensuring elections of Student Union 25-26. Now, in this notice, the president, one Aibur Rahman, his candidature was declared valid. Yes, and one Mokshed Ali, president nominated candidate, was declared valid. And for the post of vice president, one Mohibul Islam candidature was declared uncontested. Mohibul Islam. So thereafter, yesterday itself, the petitioners, petition number 2, have submitted a fresh representation to the election commissioner, which is at page number 52, annexure number 10. In this, he has clearly stated that the Aibur Rahman, that is for the post of president, and Mohibul Islam, their candidature has been shown valid and accepted. But as per the Rule 5 and the Rule 6.5.7 of the Lindo Committee, their nomination could not have been accepted because of the reason which is mentioned at page number 54. Page number 54, Lordship, there was a disciplinary proceeding against Mohibul Islam and Aibur Rahman. I'll take your Lordship to, may I read, Lordship, this notice?
Yes.
It is for general information to all concerned that as per the decision of the Disciplinary and Action Committee of the college regarding the incident occurred dated so and so in between Dr. Samir Ali and some other students of the college, the following disciplinary action have been taken. Dr. Samir Ali, so and so of the department, is removed from all the portfolio of the college held by him. He has also instructed to be an apology publicly by means of media publishing so and so. The student named Boidul Islam Mohibur Hussain and Mohibul Islam, whose candidature was declared to be valid, and Aibur Rahman, whose candidature were declared to be valid, and Hassan are hereby suspended from college for a period of 7 days. They were disciplinary action, and they were suspended. But
who are these persons?
Their candidature, Aibur Rahman has been accepted for the post of president, his candidature.
Where is that?
Page number 51, Lordship. Serial number 1. And Mohibul Islam, post uncontested, number 3, for the post of vice president.
Mohibul
Islam. Serial number 3. Their candidature was accepted. Now I will take your Lordship to the page number 29, annexure 1, from where I started, Lordship, initially. Rule number 5. The candidate shall not have any previous criminal record. He should also not be subject to any disciplinary action by the college. They have violated their own condition, which I have placed before the election commission, that is respondent number 5. But till date, no action has been taken on any of my representation was disposed by the authority. Moreover, as per the Lindo Commission report, that is clause 6.5.7, the judgment which I have placed before my lord, I have said, it is clearly stated the candidate shall not have any previous criminal record. That is to say, he should not have been tried or convicted in any criminal offense or misdemeanors. The candidate shall also not have been subject to any disciplinary action by the university authorities. So this we have
criminal part is not there.
Yes, criminal, but there is a disciplinary authority.
7 days
Yes,
suspension is there.
Yes, it is there.
So that is also.
That is also, yes.
Where is that in this?
Page number
judgment?
judgment. Lordship. That is in page number 4, my lords, clause 6.5.7.
Page number
4.
Tell me paragraph number.
6.5, Lordship. 6.5, then 6.5.7. Subclause 6.5.7.
Criminal record are subjected to disciplinary. But what about you?
Lordship, I have submitted a representation. I have also stated my attendance were above 75%, but my representation have not even been disposed of till date.
Now, on what basis do you say you are 75%? And on what basis are they saying 75%? That has to be looked into, isn't it?
Yes, the respondent
You will not be having that records with you.
Yes, we don't have the records because actually that's why that is the reason multiple representations and was placed before the authorities. But
how many representation?
First representation was given.
This is by the students, not by
Students.
you.
Joint, I have also signed in this representation, Lordship.
Oh, you also. are
My signature is also there, Lordship.
Where?
Page number 42. Below one Shariful Islam. 1, 2, 3, 4, 5. Last 5. From
Shariful.
below, Shariful Islam.
And who are there? Shariful Islam.
Petition
is-
number.
Shariful is petition number 1.
Yes, Lordship. Petition number 1 and for page number 45, the serial number 4, Sahid Anwar from top. Page number 45. Around 100 students have signed this representation and have given to the authorities, but still no actions by the authorities. In fact, the Shariful Islam has also given a separate representation, which is at page number 48, annexure number 6. He have requested for the attendance copy, but that also was not provided.
No, where is Said Anwar?
Shariful Islam, Lordship.
Shariful Islam.
Page number 48, Lordship.
48. No, signatory.
So signatory is page number 42. 42.
Where's the name?
Shariful Islam, 5th from below. Lordship.
Shariful Islam.
Yes.
And what is the one on top? 6th on top. Shariful.
Shohidul Ali.
No.
Shohikul Islam. One is Shohikul, one is Shariful Islam.
Which is the one? There's a tick mark on both.
No, the above one. Lordship.
Above one means?
Shariful Islam. Shariful Islam, Lordship.
1, 2, 3, 4, 5.
5.
The 6th one from the bottom.
Yes, Lordship.
6th one from the bottom.
Yes.
That is petition number 1.
Yes, petition number 1.
And next page, where is petition number 2?
Page number 45.
45.
45.
Shahid Anwar.
Shahid Anwar.
Where is he?
4th. 4th from top. Shahid Anwar.
Page 45.
Page number 45.
Okay.
In
This-
fact,
This representation was addressed to Election Commission.
yes, Lordship. Page number 40, Election Commission. The reasons have been mentioned in point 1, 2, 3, Lordship. May I read, Lordship? The college authority issued the guidelines rule on 7/10/25 for student union election. The rule number 5 clearly state the candidate shall not have any previous record. He should not have been subject to any disciplinary action by the college authority. Number 2, the authority misused the attendance guidelines. We all students are witness to some students of the nomination are issued valid through, though they have less attendance as mentioned by the Lingdokam approved by the Supreme Court. Some students have more than 75 attendance, even though authority have rejected the nomination paper. The authority was supposed to publish the scrutiny and declaration of valid nomination on 10, but they published on 13/10. We highly request you to cancel the election and not following the rule 5 of the college authority on 7. So after all the activity authority, we are not satisfied with the election process. We have doubt the election. We appreciate if you look into the matter and take necessary action.
This is one representation.
This is one representation.
And any other?
The second is the at page 48, Lordship, annexure 6.
48.
48.
This is by whom?
This is by Shariful Islam, Lordship. Petitioner number 1, Lordship. In this, he have submitted to the head of the department. I shall a student of so and so college, majoring in being class, writing the request. You a copy of my attendance record for academic year. This I require to contest the student union election. I would really appreciate if you could provide me the attendance. This is after the rejection. He have sent it because they won't have the copy of the register because he have been but still this was also not decided. Thereafter, on 15th, when the list was, notice was issued, they have submitted one more representation, which is at page number 52. Yesterday itself.
What is the date of, in page 48? There's no date.
There is no date, Lordship.
Second one.
Yes, there is.
So when the-
But
when
this
was
was
submitted?
issued subsequent to the publishing of the rejection list. And the last representation was given yesterday itself after the publication of the notice of the valid candidates, which is at page number 52, Lordship. This is a detailed representation which was submitted.
So how many representation in all? Three?
Three representations. So admittedly, the students who have been elected, their disciplinary actions were against them, which can be very well be taken from page number 54, which I have submitted along with my representation to the authorities. But they have not even disposed my representation, neither they are taking any action. They are validly conducting the election tomorrow itself. So that is the reason I have to approach before this honorable court. At least some protection may be given to me so that the representation, or at least these issues, can be decided. Because the Lordship, one more aspect is that they have rescheduled the entire election process midway.
Yes, who's appearing for the respondent? What do you say?
I'll be appearing for one only. And it's the internal affair of the college authority, my lord. We have nothing to do.
What university?
Question number 2.
Anything to say at this stage?
It's the internal matter of the
College.
Yes.
and it's regarding the Limbo Committee's recommendation as well as guidelines.
Limbo Committee's recommendation is abstracted in this judgment.
Yes, Lord. So my case is basically with regards to their favoritism being done to the ineligible candidates, and they have been made a valid candidates, and there is a gross malafide in the entire procedure.
Will issue notice?
Yes, Lordship, some protection because tomorrow is the election.
Heard, Mr.
F. Faridi, Lordship.
F. Faridi. Learned counsel for the petitioners, who submits that the petitioners are aggrieved with the declaration of valid/rejected nominations dated 13/10/2025 bracket annexure 4. By the Commissioner/Assistant Commissioner, election to the Students' Union 2025-26, F.A. Ahmed College, Garoi Mari.
The respondent number 5, Lordship.
Bracket respondent number 5. By which the nomination of the petitioner number 1 as president of the Students' Union and the petitioner number two
Yes. Yes, Vice.
as the vice president of the Students' Union have been rejected. On account of not having required, no, on account of they not having the required attendance percentage to contest the election. Where's the other one? Uncontested, or this one? Page 51 also, isn't
Page
it?
51.
Stop. He submits that the petitioners have also challenged the notice dated 15/10/2025 issued by the respondent number 5, by which the respondent number 8,
7 and 8.
there are two of them, isn't it?
Yes, two.
Aibur Rahman and Mokshed Ali.
No, yes, for the post of president, but I have challenged for Aibur Rahman and Mohibul Islam.
By which the respondent number 7 and 8 have been found to be eligible to contest for the post of president and by which, what did I say? Respondent number? Okay. 8, you have been found to be eligible to contest the election, while the respondent number 8 has been found to be uncontested for the post of vice president. So the learned counsel submits that the respondent numbers 7 and 8 are in fact not eligible to contest the election in view of the what do you call this? Lingdo what?
It's called Lingdo Committee, JM Lingdo Committee recommendations.
In view of the JM Lingdo committee recommendations, wherein candidates either having previous criminal records or having been subjected to disciplinary action by the college authority are not eligible to contest the election. To stop the committee's report oblique recommendation is also incorporated in the rules for election to the Students' Union 2025-2026 26 of the college concerned, dated 7/10/2025, at paragraph number 5 of the rules. Stop. Despite the same, no, despite the same, cancel, okay? The same has also been clearly established from the notice dated 11/5/2024, bracket annexure 4. No. What is this annexure?
11. Okay, this is part of annexure number
Okay,
9.
well, has clearly been established from the
Representation.
notice dated 11/5/2024, enclosed to the complaint oblique representation submitted by the respondent number, by the petition number 2, is it?
Petition number 2.
Shahid Anwar is number 2, isn't it?
Yes, sir.
By petition number 2, before the respondent number 5, on 15/10/2025, bracket annexure 10. Full stop. The learned counsel submits that although the petitioners have been found to have lacked to have, although the petitioners are found to not have the required attendance, but in fact, they do have more than 75% attendance in the college. And although representation to that effect has been submitted, by the students of the college, in which the petitioners are also signatory, on 13/10/2025, and by the petition number 2 on 15/10/2025, the respondent authorities are contemplating polling of votes and counting of the same on 17/10/2025. The learned counsel thus submits that since the action of the respondent authorities is illegal and arbitrary and in violation of the rules of election, The candidature of the respondent numbers 7 and 8 should be rejected. For the post of president and vice president.
Yes, ma'am.
And the petitioners allowed to contest the election. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. So and so.
Yes, that's.
Yes, thus.
I'll be
Accepts
appearing for
notice
one.
on behalf of respondent number 1. Mr. PJ Bukan, Standing Council, Guwahati University, accepts notice on behalf of respondent number 2. Petitioner to take steps for service of notice upon the remaining respondents. How will you take?
Registered post.
By registered post with daily due within 3 working days. Next para, having regard to the above projection. In the interim, it is provided herein that polling of votes as scheduled on 16/10/2025.
17.
I'm sorry, 17/10/2025. Where is the date?
Page number 50. Annexure 8.
Page number 50.
50. 50.
In terms of, what did I say?
Reschedule minutes of the election.
In terms of the reschedule minutes of election dated 14/10/2025.
The one thing, Lord, that in line to commission's recommendation. Lord, the election should be held within 8 weeks from the starting of academic session. 6 weeks to 8 weeks. So the notice may be a little bit
Short,
should be
huh?
short.
We'll make it. Shall not be held till the next returnable date. So issue notice of motion, I said, na, returnable by, make it 2 weeks. That's all right.
My lord is staying the entire election process or with respect to that post vice president, because petitioner is approaching.
No,
for-
because
I understand, but can it be done piecemeal?
no,
Yes, sir.
Lordship.
Will not be advisable.
It cannot be done.
This much now, this much later on like
That
that.
will be subject to my lord outcome of the election or my lord this writ petition, because other will my lord continue the post of vice president, my lord.
Ah.
My lord, he can
No,
I understand, but is it practical to
Lordship,
just
but because
allow polling for a particular thing?
yes, my lord, because otherwise
because petitioners, along with other students, they have submitted the although the 2 petitioners were able to approach this honorable court, but Lordship have already seen the representation. There are around 100 students who have written it to the respondent number 5 to consider that, but still they have not considered. So
because my lord, his right is with his legal right is with respect to that post only, my lord.
because
He cannot claim other post, the entire. They can take dusty service also instead of register post.
Very slow. Just actually, election is not a very good development. So now that is subject to the এটি কেন এলো ইহঁতে টেকনিক্যালি কন্টেস্ট কৰিবই নোৱাৰে কিন্তু তাকে দেখি চেঞ্জ কৰিব তাৰ পিছত
Thing is, will it be practical to go ahead with the other? Because there are many who are uncontested.
Yes. Yes.
We'll restrict it to the post.
There is another recommendation. Within 10 days, entire election process should be completed as
Ah.
per Lingdo Commission. So piecemeal nature, it will create some problem.
Will create problem.
Yes.
So then I think you take steps, you take by way of the Dasti.
Lordship.
Just rewrite again. Petitioner to serve notice to the respondents. The remaining respondents by way of Dasti through the registry of this court within a week. And thereafter file an affidavit as proof of service.
Lordship.
Returnable date also, we fix a date or what? I think we should have a date.
Lordship.
Today's 16.
After periodic vacation.
The suggested date, when should we have it?
After the early vacation.
Obviously.
23, 24, Thursday, Friday.
Monday 27th,
বেশি দেরি হয়ে যাবো
24th.
Dasti also then within 4 days, 4 working days. Then list the matter again on. '27 will do, I think.
Yes.
27th of October 2020.
Stay. Most. That's all right.